Okay. Good morning. This is the virtual meeting introduction. All participants attending the meeting virtually are asked to keep their microphones on mute throughout the meeting. Commissioners, division staff, respondents, and attorneys participating by camera should remember to unmute themselves before speaking. All participants should state their names before speaking to ensure a clear and accurate record. Be patient when waiting for a participant to respond, allowing time for them to unmute their microphone or in case there is a delay with the audio. Participants should speak one at a time to ensure a clear record on the recording and for purposes of preparing meeting minutes. Members of the public will be allowed to participate during the agenda items regarding public comment at the beginning of the commission meeting and before the meeting ends. Anyone participating by phone who would like to provide public comment should press star 5 to raise their hand and to be recognized by hosting staff, or press star 6 to unmute and state their name. Anyone attending by video can click the raised hand emoji to be recognized by hosting staff or unmute themselves and state their name. If anyone has any questions, issues, or concerns during the meeting, please email the commission coordinator, Amy Reverend. Her contact information is listed on the meeting agenda. The agenda and all supporting documents can be found on the division's website. If the meeting goes into closed session, all members of the public and division staff not involved with the agenda item will be placed in the virtual lobby. After closed session has ended, participants placed in the virtual lobby will be brought back into the meeting to hear and or view the commission make a decision. To receive CE credit, your camera must remain on throughout the meeting and you must give the meeting your full attention. Once the meeting adjourns, CE certificates will be emailed within 5 business days. If you have any questions, please contact the division's education section. And please note that the Teams chat function is intended for staff use only. Okay, that's the ending of my virtual introduction. Thank you.
Good morning, everyone. This is really a full house. This is wonderful to see. Everybody needs to get relicensed soon. Okay. I will now call the meeting of the Nevada Real Estate Commission, February 10th, 2025 to order. We'll begin with the agenda, starting with item number 1A, introduction of commissioners in attendance. And I'm going to surprise someone and start to my left.
Wow, how about that?
I don't know.
Brad Spires, the hinterlands of Douglas County.
Forrest Barbie, Clark County.
Chris Rayner, Washoe County.
Dave Tina, Clark County.
I'm Donna Ruthie, and I am Clark County and the Real Estate Commission person. Next, we have Commission Counsel to my right. Introduce yourself.
Stephanie Aiken Goodman.
So moving on, I'm going to start agenda item. Introduction of division staff with us this morning. And have our division administrator. And excuse me a second, can we see? We want to hear you.
Someone's.
Sorry about that.
Oh,
Good morning, Commissioners, Madam President, Bharat Chandra, Administrator for the Real Estate Division. We've got Jarvis Foger, Deputy Administrator. In the Administration section, we've got Sharice Bates, Maria Gallo, Amy Reverend. Compliance, we have Chief Rebecca Bruce with her team. James Silva is up north from the Education section. And Ellen Carrillo and her team are here. The AG's office, we've got Phil Sue, and I believe it's Bill Pepper. And Bill is new, so welcome. That's our staff for today.
Thank you, sir.
Thank you.
Members of the public, I'm going to move to agenda number item 2, public comment. Members of the public are encouraged to address the commission regarding any matter. However, no action may be taken on a matter. No comments may be made regarding a matter that is or may be subject of a formal complaint before the commission till after the matter is heard. Comment may not be limited. I'm sorry. Yes, that's right. Comment may not be limited based on viewpoint. Persons who desire to submit written testimony should submit 7 copies to the commission coordinator. Anyone participating over the phone that wishes to provide public comment should push *5 on your phone to raise your hand, and the hosting staff will recognize that you would like to give public comment. Or you can press *6 to unmute yourself and state your name. If you are attending by video, click on the raised hand emoji to indicate you would like to give public comment, and the hosting staff will recognize you. Or you could simply just unmute yourself and state your name. Public comment may be limited to 3 minutes per person at the discretion of the president. And also, I would like to remind everyone, if you are making a comment, just please state your name and spell it for the record. Thank you. Any public comment here in the Las Vegas room? Hearing none. Any in the Carson City room? Hearing none. And Maria, could you
There's
check?
none in Carson City.
Thank you. Maria, could you check if there's anyone attending virtually that would like to make public comment?
Yes, if anyone virtually would like to give public comment, please use the raised hand emoji, or you can just mute yourself and state your name for the record. I am not recognizing anybody who would like to give public comment.
Thank you, Maria. I would like to remind everybody we have a stacked agenda, which just means we'll be moving through this agenda for efficiency, so it may not go the way you see it on the agenda in front of you. I'm going to start with item number 3 on the agenda, which is Commission Division Business. A, the administrator's report.
Good morning, Commissioners. I'm President Sharat Chandra, Administrator for the Real Estate Division. It's to start off the Administrator's report, give you a brief overview. I think we've talked about this before. We have a technology project that we're working on. We are, I want to say, making good progress. Just with technology, there's always issues with the developer, but we're working through it. I think our goal is to still get a product out there that's better than what we have. Online applications, payments, renewals, all that fun stuff. We're working on a module for education, which I think is an important piece of it. We've seen a really good demo of the education module of what it could be. And so we're exploring that. We're going to try to add it to this project just seamlessly, and hopefully we'll get it all delivered. So that's the goal. So we're chugging away. But again, for the record, we want to thank everyone for their support on this technology project, for allowing the division, to giving us the resources and the support to have us get to this point. So we appreciate that. And so that's the update on the technology. We are gearing up for, believe it or not, the next legislative session and budget. So we've already, for the division's purposes, we're already working our budgets. From the real estate side, this one is, again, another important session for us, but also from a budget and planning perspective, it's important for us. Our goal has always been to provide as many resources as possible to the licensees and also provide resources to the public to help them. So resources wise for the licensees, it is to offer better and more services. And so that has always been our goal, whether it's education, whether it's licensing, whether it's compliance. One of the big asks has always been to try to open a northern office. I think it's just overdue. It's something that we've been struggling with. And as you all know, historically, the recession, the financial crisis, having us close down offices, and we're still pre-2009 staffing level. So we've been gradually trying to increase it. So the goal is to get a northern office open, get some licensing functionality there. The online modules will help greatly reduce that. But unfortunately, the whole mailing to the south is just not work. And we all know that. That's the reality of that we're living with. But we're going to change that. So the goal is to get a northern office open, We also want to add maybe another position in the compliance section, just to deal with the volume, the calls, the walk-ins. As you know, our goal here is to kind of filter the issues that come through the division and then move them along to compliance, but also solve a lot of the problems, answer the questions. So the volumes have increased, phone calls, walk-ins, emails. And so to deal with that volume, we need some more support. So those are the two things, but underlying all of that is for us to be able to do that, we have to move to a model that is self-sustainable. So for folks here, I'm just repeating the same thing over and over again. But for folks that are listening into, it's important to understand that the real estate division is one of the few agencies that is funded through the general fund. And from our perspective, it's just not sustainable because the general fund has a lot of priorities: health, safety, education, fire, police. And so all of those get funded and there's not enough left for us at the end. And so 40,000 licensees and growing, and a lot of the demands of the industry and the changing trends, for us to keep up and maintain that level of service, it's impossible under the current circumstances. So the goal is to say, if licensees are paying into the state for their licenses, that money needs to be used for services provided back to the licensees, whether it's education, licensing, compliance, enforcement, all of those. And so that has always been our goal. Looks like we are in a position where the state understands it, the governor's office understands it. Now it's a matter of figuring out the monetary aspect of it and the budget aspect. So the director of business and industry is going to propose a GovRec, which is essentially they're going to consider that as a governor recommended option to go self-funded, which is to decouple from the general fund and have the agency stand alone. And the question has always been, what does that mean? Does that mean if there's a recession, if there's a drop in revenue, what happens to the division? And my answer to that is same thing would happen if we were in the general fund. Except in the general fund, we don't control our own destiny. General fund controls our destiny. So if there's a drop in revenue, we then end up having to get into the list of priorities, which, like I explained before, we get to the bottom of the priorities. And so there's not enough left for us. So when we self-fund, then you entrust the division to and the commission to make the best decisions as far as fiscal responsibility, where the priorities are, and what to focus on. And that's kind of the way you want it to. And that's how the vast majority of agencies that are licensed agencies perform. We're one of the exceptions. What we've tried to do over the years is to demonstrate that this commission is the benchmark for most commissions. Most commissions look to the Real Estate Commission on how things are done, how cases are heard, how deliberations happen, and how discipline comes through. Very few commission decisions are challenged because there is deliberation, there's review, there's due process. And so that is how it should be. And so we use that as a model. The other thing that we don't do is we don't rely on fines and fees to sustain the agency. That is not our goal. So when the commission deliberates, it's based on the facts, and the fines and the decisions are based on the facts. It's not revenue that the division ever uses. And so the incentives are not there for the division to push for fines and fees. Those are just course of business and the commission's decisions on fines. And so that money goes directly to the general fund. We don't really take a part of it. And I think that model works really well for us. And we want to keep that model. But to keep that model, we need to be self-sustained. And so it comes back to that. And that's kind of our goal this session. So we look for support from the associations, from all the licensees. If you're not clear about what this means, how this affects us, please talk to us. Please reach out to your commissioners. They've been here for a long time. They understand the history behind this and why we're doing this. And if there are things that we're not doing right, let us know. Because we're always open for feedback. We're always open to constructive criticism, and we want to get better. That's all I have. So that's the budget piece of it. The self-funding piece is something we're working on. I anticipate it to be a very busy session for all of us. We also have a lot of bills on this HOA side that we're working on. We have a HOA task force that the director of BNI has put together. So there might be some recommendations coming from there. Again, ultimately, the goal is to also allow for HOAs to be self-sustaining, to be able to operate, also have the independence to make decisions that's best for their community. So that's, again, our goal. We have an ombudsman's office that works with homeowners. Again, the goal of the ombudsman's office is the same thing, is to solve these problems before they become big and they escalate. So they're working really hard. We have a staff. So if you folks have issues with HOAs, please reach out. We'll talk through it and we'll try to figure out the best solution. We also have an education section there that supports HOAs. Our ultimate goal is to have an education section that speaks to everyone in the same voice. So whether it's real estate, HOAs, it's all housing, it's all communities. So we want to the division needs to speak to all of these issues as a whole. So that's another goal of us, is to create an education section that encompasses education, licensee education, HOA homeowner education, public interest, and make it a little more seamless. So sorry, didn't mean to go that long, but that's my report.
Very informative.
I'm open for any questions.
No questions.
Thank you.
Thank
Appreciate it.
you. A, move to D, disciplinary.
Good morning, Shrews Bates Administration Section Manager for the Real Estate Division. In your packets, Commissioners, you have the most updated disciplinary report that was last updated January 27th. So this is a reminder, anything that's happened since our last meeting would be highlighted in yellow. So essentially that's if any payments were made, if any education was ordered and completed, and then it would be grayed out if that person has needed their ordered discipline. So that's what's reflected on that report. It also, if you see what's in red, our individuals forwarded on for further debt collection proceedings, should they not have met their ordered discipline. Any questions? It's hard to follow that, so.
Thank you. And we have C and D under number 3. This from our Chief Compliance Officer.
Good morning. So in the packets, you have the enforcement data and the AdSync report. These are figures through December 31st. Oh, sorry, Rebecca Bruce, Chief Investigator. The administration sanction report includes all the administrative sanctions imposed since the last report to you at our meeting in November 2025. During this period, we've imposed a total of 41 administrative fines for a total of $14,500. The enforcement data report reflects activity through the first half of fiscal year 2026. So far in fiscal year 2026, we've received 41 complaints in the north and 750 complaints in the south, for a total of 791 complaints received. We opened a total of 222 investigations and closed 192. We currently have a total of 194 complaints under investigation. So far in fiscal year 2026, our enforcement section answered 2,688 phone calls and met with 329 members of the public and licensees in person to provide information and assistance. Current issues under investigation include brokers failing to submit their annual trust account reconciliations to the division, brokers failing to submit their affidavit informing the division that they have not handled money belonging to others during the prior year. That's the Form 546A. Agents who do not include the name of their brokerage and real estate license number in their advertising or misleading and false advertising. Unlicensed real estate activity by local individuals and out-of-state licensees. Unlicensed property management activity to include real estate licensees and unlicensed individuals. We're seeing an uptick in business broker activity, unpermitted. Failure to disclose material of relevant facts regarding the property that is subject to transaction. Trust account reconciliations submitted by brokers indicating suspicious, questionable, or mishandling of monies belonging to others. Property managers failing to account for or remit funds to include failure to promptly remit and account for rents to property owners and security deposit refunds to tenants. This is one that's we've seen an uptick recently, is trust account embezzlement or mismanagement of trust accounts to include brokers, property management, or employees stealing monies held in trust accounts that belong to others, and brokers failing to recognize that until it's too late. Brokers failing to properly supervise their licensees and employees, and failure to provide duties owed form prior to the execution of transaction documents. And finally, brokers failing to return agent license to the division within 10 days from termination.
Thank you
Any
very
questions?
much. That was very interesting. And now we have continuing education.
Good morning, Madam President, Commissioners, Annalyn Carrillo, Education Information Officer. Not as interesting, but before you have, yes, education summary. Since our last commission meeting in November, we have a total of 41 new continuing education courses approved. And with November 22, December 11, and in January, we approved 8 new courses. Before you see the roster uploads, we had a total of 3,822 individual roster uploads with a total of 33,332 individual licensee uploads. And with a total of 1,250 errors, which has decreased over the years due to our educators being more responsive and ensuring that their rosters are submitted correctly. And so we're happy with those numbers going down. And the total approved courses listed by designation currently for continuing education alone is 918 courses.
Thank you. This is interesting. I'm sure everybody will tell you.
Thank you.
Thank you. Okay, we're going to move on to E, which is the discussion regarding the commission's opinion of the handling of real estate sales. And if you remember back in August meeting, Susan Russell was on and gave a statement, and she also gave a 3-page letter, which is in our packet. Do any of the commissioners have any input on this discussion, or if it needs to move to, and I welcome help from our administrators and our deputy administrator. If this needs to move maybe to the appraisal committee or somewhere else,
Yeah,
not
that's-
sure if this is.
How I feel.
Hello again.
Brad Chandler, Administrator for the Real Estate Division. I think you're on the right track, Madam Chair, President. So I think we can have a general discussion. Just kind of, don't go off and give personal opinions on this. Just have a general discussion on what commissioners see on this matter, and then we'll move it on to the appraisal section. Then we could put it on the agenda there for them to discuss. And then we'll come back to you folks and kind of report on what their thoughts are.
Okay.
And then we'll kind of go from there.
Okay, great. Thank you.
That makes sense.
Any comments?
I just felt that, for those you who don't know, basically, this person does estate sales and she's licensed, and she feels that us as realtors are out of our area of expertise by selling antiques, furniture, or whatever we're doing, and her recommendation was for us to do something. My thoughts on this is that it isn't this Board of Commissioners that would handle this, and that there's alternatives to get that out, but I don't see it as this board. Thank you, President.
Any other comments?
Yeah, Commissioner Barbie, I would certainly agree with Mr. Tina on that, because in what I discovered, the licensing really is county. And we already have provisions for handling situations where somebody's where complaints are filed, where people are acting out of their scope. And so those mechanisms are in place. The same thing through the county and the other agencies. there are ways to handle infractions. So I'm not certain that we would do anything more than you've already suggested.
Commissioner Spires, I think her letter is really well written and I think it is an issue. I think it's an issue that should be addressed. I just don't see that this is the body to address it. And I agree with the administrator that it probably is over to an appraisal. I think it should see that. More thoughts.
Thank you, Commissioners. Thank you. Just a quick comment. Forwarding it definitely would be your committee would be the best. And I know Susan, I've worked with her a few, and I've come across agents on some homes that there were antiques there and people that were selling their homes of age, which I'm approaching soon, so I'm not pointing fingers. I'm already there. That we're taken advantage of along the way. And it turns into a long lawsuit and it's a nightmare. So her points are so valid. I'm glad we're going to move. She may be taken.
Thank you, Madam President. So Sharad Chandra, Administrator for the Real Estate Division. So we'll do that. I think the other piece is if there is an appetite, maybe there's some educational things that we can work on to put out there that will engage with the licensees so they understand. It's like, you know, for me, and this is just my perspective on this one, is it's almost like property management. So you need to know what you're getting into before you get into. But again, when we had the discussion about property managers, it was again, educate yourself before you go into that specialization or you want to do that because there are consequences to that and you have to understand what you're getting into. So what we'll also do is we'll take our packet that was submitted. We'll use that also as backup when we do the appraisal discussion on that. So they have more context and then we'll report back to you on what that looks like. And we'll look at I think the county one was an interesting one. I'd never thought about that. So we'll look at that angle too. It may be there's something there that we can point to and say, you know, that's something the county can look at.
And just a quick footnote. Susan Russell did offer at the August meeting, if any other committee or staff, and I think you have her information, wants her to participate or give information, she's more than willing to.
Commissioner Barbie, again, along the same lines, we get this to the appraisal side. Would there possibly be an opportunity for a joint information bulletin released by both appraisal and real estate division as an educational piece?
Taking all my thunder.
I knew that he
No, I
was.
think, no, I think that's great. I think that's exactly what needs to happen. And I think that's probably what we'll do. I think that's brilliant. Thank you.
Thank you. Okay, we are going to move on to item G, which is the November 4th minutes. Motion.
Motion to approve.
Second.
Yeah, motion to approve in a second. Any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed? Chair votes aye. Thank you. Which just,
Commissioners,
Yes.
we have a small request to speak a little louder over the air so that the back of the room.
look, I brought a seat. to get-
I know, we talked about it, but this projects. We're gonna project.
Should I take that as personal? No, I'm teasing.
You can do it.
I'm teasing. Thank you. I'm gonna make a, thank you. I'm gonna make a little bit of a switch. I was going to start with a different case, but I've been made aware that we have a stipulation case. I'm going to ask to hear first and go on with the case. So I'm surprising our attorney, Mrs. Sue, which I like to do, but he did ask.
Thank you.
And it,
Sure. You want to call the matter?
I'll hold it. So, Nevada Real Estate Division versus Casey Clark. Case number 2025-305, and I understand that they were working on a stipulation.
We were. I had informed Mr. Walk that we might be taking his case out of order, so I certainly hope he's still online. Mr. Block, are you online and available and paying attention?
Yes, I'm here. Yes.
Fantastic.
Good morning.
Thank you. If you could,
Good
for the record, Mr. Block, just go ahead and state your full name for the record.
Yeah, Casey Andrew Block.
Thank you. And for the record, my name is Phil Sue. I'm the Senior Deputy Attorney General appearing on behalf of the division. So in this matter, we are happy to report that the parties have arrived at a settlement stipulation. We should have a signed copy that should be in front of you, but it was definitely delivered at the 11th hour, and we apologize for that.
Or disciplinary? Okay, it has been loaded in our disciplinary.
So this is a failure to file trust account reconciliation form 546D matter, which, as you know, is relatively direct. I can, at the chair's preference, either provide that summary or provide, actually read the actual allegations.
I was going to ask you to read the actual applications, please.
Certainly. Number one, at all times relevant to this complaint, respondent has been a licensed broker with the Nevada Real Estate Division, license number B.1002537.LLC. Number two, respondent's broker's license was first issued on December 31st, 2020. On January 25th, 2023, the division, through Chief Investigator Jan Hawley, sent a courtesy email to respondent reminding him of his obligation to annually submit a trust account reconciliation form 546 or 546A, and reminding respondent of the annual deadline for submitting the form, last day of December, which was the expiration date of his broker's license. On January 14th, 2025, the division, through Chief Hawley, sent a courtesy email to respondent reminding him of his obligation to have submitted the trust account reconciliation form 546A by the last day of December 2024, and informing him that he needed to remit the form immediately or he would have to pay a $250 administrative fine. On April 7th, 2025, the division, through investigator Lisa Galletto Smith, sent an additional email to respondents regarding his trust account reconciliation obligations. On April 28th, 2025, the division sent respondents a notice of violation letter to his address of record notifying him that the division was imposing a $250 fine pursuant to NEC 645.695. The letter instructed respondents to complete and submit the attached 546A form and advised him of his appeal rights if he disagreed with the finding of violation and or the imposition of the fine. Upon information and belief at respondent's request, his license was converted to inactive status on or about May 8th of 2025. On June 24th of 2025, the division sent respondent a follow-up to the notice of violation letter indicating that he had not yet submitted the 546A form for 2024 or paid the $250 fine, and that if he did not remit payment of the fine by July 8th of 2025, he could face further disciplinary action. Following day, respondent emailed the division asking if he could, quote, have more information regarding this, unquote, and noting that he, quote, canceled/terminated his license months ago. Quote. On June 26th of 2025, Division Investigator Smith replied to respondent's email noting that the Form 546A trust account reconciliation due by December 31st of 2024 was never submitted, and that although his license termination request was received, that submission occurred after the form was overdue, and noted that respondent did not respond to multiple letters and emails from the division to rectify the discrepancy. On October 3rd of 2025, the division issued an NRS 233B letter via certified mail, informing respondent of the division's intent to refer the matter for hearing before the Real Estate Commission. There's one legal allegation set forth in the complaint that respondent violated NRS 645.633 subsection 1B pursuant to NEC 645.606 subsection 2 by failing to timely submit his annual form 546 trust account reconciliation form to the division by the last day of the expiration month of his broker license, December of 2024. And here's settlement terms. By entering into this stipulation, the respondent does not admit the above factual allegations, but agrees to waive his right to contest the above allegations if the stipulation is approved by the commission. Accordingly, in an effort to avoid the time and expense of litigating these issues before the commission, as well as any possible further legal appeals from any such decision, parties desire to compromise and settle the issue in controversy following the following terms and conditions. Number one, respondent agrees to pay the division a total of $1,402.40, consisting of 0 additional administrative fines, the division's pre-hearing costs and fees in the amount of $400, and pre-hearing attorney's fees in the amount of $1,002.40. That amount payable to the division within 60 days of the effective date of this order, and no grace period is permitted. If the payment not actually received by the division on the report's due date, that will be construed as an active default by the respondent. And second, by entering into the stipulation agreement, respondent represents that he has already paid the existing $250 administrative fine as set forth in the notice of violation letter and submitted his delinquent 546A trust account reconciliation form to the division. And I can confirm that he has done that. The rest of the terms are boilerplate, and I submit this matter for consideration.
Thank you, Mr. Sue. Does the commission have any questions regarding the stipulation, settlement, or disciplinary action?
No.
Does the respondent, do you want to say anything regarding the stipulation of settlement? Any comments?
Yeah, I'm representing a tech company as the broker. So this was simply an administrative oversight. The company was going through an acquisition, so it was just an administrative oversight. And there's no trust account that exists. So yeah, there's no transactions that exist. This company was for MLS data purposes exclusively. So yeah.
And just a word, not submitting this form, a tech company with follow-up, not submitting the form caused a lot of work and cost of the fees and fines to go up. So we're here for education too. So I just want to bring up how important that trust account is for brokers to fill out.
Yeah.
And did you sign the stipulation and agree to the terms?
I did, yes, and I certainly understand that. I've been a broker for a long time, so my apologies.
Appreciate that. Thank you. Do we have a motion?
Yes. Well, Commissioner Barbie, I move that in the matter of NRED versus Casey Block, case number 2025-305, that the commission accept the stipulation as presented.
Second.
We have a first and we have a second. Any discussion? Hearing none. All those in favor say aye.
Aye.
All opposed, nay. Chair votes aye. Motion carries. Thank you all. Thank you, Mr. Casey.
Thank you.
Thank you, Sue. Just give me a moment to go back because I booked something out of order. Okay, we are going to go to the agenda 5A, NRED versus Katrina Jet, possible action, case number 2024-680.
Hi, Michael Van on behalf of Ms. Tiff. Just talking to council. And I was just going to offer something if not, we've never really had an opportunity to meet. Reasonably complicated.
Should you just speak a little louder?
I've never had a woman in my life ask me to speak louder.
This
This is a public where's the transcript? And it's my wife. Wait till you speak up. I apologize. It's a reasonably complicated case. I've never had an opportunity to meet with council. I would like to see if we could pass it to the next meeting to give us an opportunity to go through this. If not, I've got 35 exhibits and 5 hours of testimony that I'm sure you don't want to go through. Not having had an opportunity to try to resolve it first. And if that's okay with you.
So Bill, for the record, my understanding is, having consulted with my client, they probably were looking to move this forward as a contested case. It had been continued already since the last stack. And so,
I understand that, but we didn't have counsel, and it is reasonably complicated.
may I ask the procedure being used as
that
president?
might be a question to ask the commission council as far as the procedure of that.
Okay,
But
excuse me for a second.
Can we get your name for the record?
I'm sorry, Michael Van, VAN.
Thank you. Mr.
Law firm is VC2 Law.
Thank you.
Excuse me, we're going to take a 5-minute recess.
Thank you.
Good.
And I apologize. I should have. I didn't know who to get hold of before. Now I do.
think we are back in session here, and this is the time and the place for hearing in the matter of agenda number BC. This is agenda number 5A, Rena Jet, case number 2024-680. Is the respondent here?
She is. She's present.
She is present.
One second. Yes.
Right, thank you. And we have counsel here. We have the commission.
And Division Counsel Phil Sue for,
Are there any preliminary matters you want to start with?
yes, please. I think Mr. Attorney Van, Phil Sue for record. I think Attorney Van had mentioned his requests, and I think it may be best for both parties to, again, reiterate what is being requested and what their position.
So we're going to handle this a little bit different than a regular hearing. Are you going to guide along the way here?
It's a preliminary.
I'll blame you if something's wrong. Okay, so are you making the opening?
It's not my request. That would be Chad's attorney.
So it's
let-
changed.
He should be here.
Okay.
Madam Chair, I've been practicing law for 40 years. Every judge has one of those gavels, and I've never seen it used except for today.
You'll see it's used a lot.
Judges don't use it. I don't even know why. This is a reasonably complicated case, and I will tell you that I'm going to choose my words very carefully. Am I loud enough?
No,
No.
no.
Okay.
I can tell.
I'm going to choose my words very carefully. The basis for a lot of this is because there was an underlying court case. In that underlying court case, I have never seen an attorney, one, tell his client, don't show up at trial. Two, not offer any evidence whatsoever. Three, not put into evidence the underlying deed. Four, never call a witness, don't cross-examine a witness. And yet, as a result of that, there was an underlying court case that found my client guilty. Fortunately for us, you all get to look at it de novo, which means that we end up essentially retrying the case. There's a lot of evidence that I would like to print, and Mr. Sue was not counsel. We tried to contact prior counsel to have this dialogue, and she had left, identified a new counsel. And as fate would have it, we had Mr. Floth and I just got out of what started out as a four-day trial that ended up being a 8-day trial and mediation. So we really haven't had an opportunity to sit down and talk with Mr. Sue. I believe that we can come up with a stipulation for resolution. I think when all of the evidence is laid in front of him, and rather than lay out 5-6 hours worth of testimony, we may have a 20-minute stipulation. And I just want to be cognizant of everybody's time. We do have evidence to support it. I will proffer to you all that there is evidence showing the intent of the parties, that there was a viable transfer, that the relationship between father and daughter, and that the underlying cause of this has to do with sibling conflict after the father passed away. Most of that has been resolved, but now we're talking about someone's ability to, her livelihood. And she wants the opportunity to present that, to show that she really didn't do anything wrong, that everything was agreed to between her and her dad, but that all of that evidence was not presented at the underlying case. And so we would have to go forward with all of it today in order for her to save her livelihood, to save her meal.
Mr. Sue, can I ask a question of you? Sure. Or if it's yours, jump in. So I'm a novice, not an attorney.
You need to speak up. I was cautioning. I was kidding.
I have a little problem hearing some of the case like this because we don't hear the other side. That is not here right now, the person that filed, right?
The person that filed.
I mean, are we going to hear the other side? Because we're hearing part of a case that happened. And I'm kind of not comfortable with it.
You're going to hear from the division, its investigation.
Correct.
Which also encompasses what the complaint has said.
It's going to go over a previous case also.
Well,
It's, if you're not going to go over the previous case and give us that side, then I don't think we should.
I think they're intertwined. What comes up is, well, from the outset, I think we are diametrically opposed as far as it is the division's position that we are not here to relitigate.
Right.
What we have is a district court decision that has a clear fact pattern that was affirmed by the Court of Appeal 3 years later in 2020. But even that of which you can take administrative notice of that. Separate from that, we have a division investigation with its own separate corroborating evidence. And so all that is evidence. You can assign whatever evidentiary value you want to both of them. We are going to ask for administrative notice of those judicial findings, but we are also going to provide the documents and the information that our investigator obtained during her investigation as well. So we're not looking to relitigate the details of that underlying case, but there is significant overlap between the two.
I'm just listening to it.
So you asked for a continuance once, is that correct?
It was before we were involved, but yes.
It was a different attorney that asked for a continuance, is that
I
it?
believe that she may not have been represented. I'm not sure.
She wasn't represented.
She lost, okay, so we gave her one. Okay, and so you're coming here now to say, can we give more time so that
So that I can
you
meet
can
with
meet
counsel.
and possibly get this settled?
And try to
into
short
stipulation?
Abraham Lincoln once said, every attorney should try to resolve every case, and there will still remain plenty of work for all of us. We haven't had an opportunity to try to resolve the case because of the change in the office of the
The
attorney.
office.
And I would like to have that opportunity.
Thank you. Do you want to say? something?
Yes, in response to that, I think the first position is, I already have consulted with my client. And I think stipulation is kind of a non-starter as far as the division is concerned. If only because this is a matter that should be heard and not necessarily kept from the public eye. In terms of, it is educational as far as what are licensees' responsibilities, even when there may be commingled family relationship. When we're talking about something, especially where the evidence was established in district court, and yeah, there may be underlying issues regarding that. We also have an investigation that has its own information that our investigator obtained. So it isn't standing alone. It's not something that just because the district court case happened, here we are going to throw a book at her just because that happened. Yet we do have a separate investigation that our division itself also undertook. Now that they both happen to reach the same conclusions, and that may not be a coincidence. But we'll leave that to you as triers of practice. When we come down to it, I think the division's position is that Ms. Jett, be that as it may, that she may have hired an attorney later on, she has technically had 4 months to prepare. And the division stands today ready to pursue case of contested case if we need to. And I don't know that having the opportunity to reach any kind of negotiation stance would necessarily change the position of the parties 3 months.
So being this is new to me, if I'm wrong, somebody's going to jump in here. I was going to turn to the commissioners and ask if there's a motion to move it forward or to.
A motion followed by questions that they might want to ask of us. And I suppose if Mr. Van wants to be heard again.
Well, I know the questions. I'm saying we need a motion on the table first before we do questions.
And I think the motion would be based on a request from Attorney Van
Correct.
to continue.
Either, right. So we're looking for a motion, whether we're going to continue this into a hearing or deny that request.
President Ruthie, I make a motion to hear the case at this time. Second.
We have a first and a second. Any discussion? Okay, hearing none. All those in favor?
Aye.
Aye.
Opposed? Chair votes aye. Okay, we are going to move forward hearing.
We've got some stuff.
I'm sorry, I missed you. You said I apologize.
I was just gonna grab.
Oh, sure. Take your time.
Yeah.
Your witnesses.
Um,
The normal.
Cases and sheets, statements, cases and sheets.
We'll go back. Just let me know whenever you see it. Ready to go? Okay. So we are going to go back here and we're going to start with the opening statements and it will be the division counsel.
Thank you very much. For the record, Bill Sue on behalf of the division. This case is Not that complex, really, when you get down to the report. It's about a respondent who allegedly committed fraud in the inducement and misrepresentation in the course of representing her 88-year-old father in the purchase of of real estate. Peter Nicholas, Senior, I'm going to call him Peter Senior for purposes of this hearing, was an 89-year-old Vietnam veteran. And he trusted respondent, his daughter, Karina Jett, a real estate agent, to help him find a home that he could purchase with his VA benefits. On her advice, purchased 889 Luster View Court, Las Vegas, Nevada, a 4-bedroom home. By all initial indications, he would live in the home and the respondent would manage the rental of the other bedrooms, pay mortgage and expenses, and split any profits with him. That was the plan anyway. Peter Senior put down his $15,000 down payment, and a VA loan was taken in his name only, which required him, the veteran, to reside in a home as his primary residence. Closing happened about April 21st of 2015. About 2 weeks later, on May 1st of 2015, respondent Jett convinced Peter Senior to add her to the deed as a joint tenant with rights of survivorship. As it turns out, respondent had no intention of letting Peter Senior live in the house that he had purchased in his waning years. Instead, shortly after closing, she locked him out of the home, claiming that no one would want to live with an old man. Peter Senior never lived a day in that home and would never be able to, as he passed away on October 2018. Now, these facts are corroborated by the division's investigation, but you don't have to take just that alone. Indeed, these factual determinations were also conclusively established in the Nevada Clark County District Court case A-17-763341-C, Peter Nicholas versus Karina Jett. Following a bench trial there, Judge Sturman issued her decision and order filed September 15th of 2021, finding that evidence supported Peter Senior relied solely on the respondent's advice when purchasing a house, and that he added her to the deed in order to avoid probate, and determined that they were in a confidential relationship as between a real estate professional and client, not merely as parent and child. Notably, the court ordered rescission of that joint tenancy deed, adding that respondent as a respondent had procured it through fraud. That's the quote. The district court's decision was affirmed by the Court of Appeals in case number 84032-COA, dated January 31st of 2024. In making its case, the division plans to call one witness, investigator Shannon Goddard, to testify regarding the details of her investigation. The division alleges 4 violations of law. NRS 645.630, subsection 1A, failing to possess the qualifications of honesty, trustworthiness, and integrity required all licensees when it was uncontroverted that she committed fraud in the inducement and or intentional or negligent misrepresentation in a real estate transaction. Or NRS 645.633, subsection 1H and 1I, for committing deceitful, fraudulent, and or dishonest acts in a real estate transaction and for breaching her obligation of absolute fidelity to her father client's best interests. And lastly, for NRS 645.252, subsection 2, when she failed to exercise reasonable skill and care with respect to all parties of a real estate transaction, when she was clearly advancing her own self-interests. The division and the state are confident that they will establish all of these alleged violations of law by preponderance of the evidence on conclusion of this matter, and we thank you for your service.
Thank you, Mr. Sickle. Respondents, counsel.
Thank you enough. I'll identify Mr. Floth is a new attorney, and so I'm going to ask him to do a lot of the questioning of Ms. Jett. I will cross-examine, trying to train as we go. You're trying to train, so it's very important that a couple of things that we find out with Ms. Jett. Number one, she's been a licensed realtor.
Sir, you're all going, they can't hear you.
One of the things that's very critical is that we understand that Ms. Jett is a licensed realtor and has never had any complaints for 14 years. There's one issue, and it has to do with a family-related issue, with a relationship between her and her father. There was, after her father passed away, or excuse me, right before her father passed away, he was induced by his son to file a lawsuit against his daughter. And at that lawsuit, then shortly after that, he passed away. The son then elected to continue on with the lawsuit. So it's not as if father was suing and we had the opportunity to hear father at trial. We did not. So most of the testimony you're going to hear is between Miss Jett and her conversations with her dad. There is an underlying case, and in that underlying case, it's problematic, and I'll admit that. It's problematic because I have never seen in 40 years of practicing law an attorney say to a client, don't show up to trial. And I've never seen a case where an attorney doesn't offer one shred, not one piece of evidence. More importantly, there's a difference, and I apologize, I don't know how much you know about the legal system. There's a thing called a proffer. You don't even have to offer it. You just have to proffer and say, I have this evidence and I will submit it. He didn't do that. He didn't submit even one exhibit. And part of the exhibits that we're going to show you is the exhibit binder that shows that he did not submit a file, not a document in defense of Miss Jett at the underlying case. And there was a finding. Well, of course there's a finding. It's really easy to point at the empty chair and say, yep, you're at fault because there's not another side that's been presented. We're in the process of trying to find and locate, which, trust me, that's difficult, an attorney to file the malpractice case. And we may end up doing it ourselves. You just can't do that. So what's the basis of this case? Mr. Michaelis Sr. was living in a condition where he basically said to his daughter, look, I need to get in a different position in my life. She talked with him about a house. They found a house that he could rent the one room, rent out other rooms to other individuals, and make enough money to pay the mortgage on the house. So they did that. She found him a house. He looked at it. He wanted to move into that house. He moved items to the house. However, he was also in a relationship with a girlfriend who said, look, why don't you just rent out the other room and move in with me, which he did. And he bought the house under the VA, and the intention originally was for him to move into the house, but then he figured out that he could live rent-free with girlfriend and make more money by renting out all the rooms in the house. Shortly after the close, the house was transferred into the name of Mr. Michaelis and his daughter, and it's handwritten. It will be Exhibit BB, and it shows that it was handwritten by him, and it says transfer between father to add daughter. There's no evidence of fraud. Even at the trial, if they would have put this up there, it's a document that is notarized. They didn't even call the notary to come in and say, did he come in and sign it? What was his mental condition? What was anything? None of that was presented. In order to establish fraud, you have to show some other event. You have to have some way to validate that, just not, yeah, he was defrauded. Well, the document establishes that he, in fact, was not defrauded. It's his own handwriting that transfers from him to him and his daughter. More importantly, from the time of the closing, Miss Jett makes sure that every mortgage payment was paid. If it fell short, if she didn't have renters, she came out of her pocket. What about rental insurance? Well, he sent over to the bank confirmation that said, I need her on the mortgage account. And it's been confirmed, and evidence will show that. More evidence that wasn't presented in court. It shows that he put her on the insurance policy to make sure that there was insurance. He ensured that there was a renter policy to ensure that they made that if anything happened, that they could go to the renter's policy. But everything indicates that there was an agreement between father and daughter to do this. Well, why would he put it in her name? Well, the reason was because he wanted to give her something when he passed away, and he was giving her the house. There are resolutions with the bank that resolve that she have the opportunity and the authority to act in his behalf that he signed off on. There's documents that went to his house from the bank that said, okay, this is just confirming that you want her on this account. And that's what happened. They put her on the account. In October of 2018, Peter Sr. passed away. There was originally, when they went to transfer this deed, there was an original submission that was denied because there was not a declaration of value. So they had to go back to him again So he essentially submitted that deed on two separate occasions. I think it's very important that you listen to what Mr. Sue said. There's a very clear fact pattern. It's not a clear fact. There's a clear fact pattern if you only hear one side of the story. But when you hear the second side, when you see the second piece of, or the second side of that piece of toast, you realize that maybe there's another story. And the problem is and I don't blame the division for relying on the court order. I get it. I understand it. And I understand that when you go up on appeal, well, on an appeal, a record on appeal, you can only decide based upon that record. Well, guess what's not in that record? Any defense. So when you file it, and the argument was the ineffective assistance of counsel and the fact that she wasn't there, they said, well, yeah, he probably should have invited you, but on the record on appeal itself, there's nothing to overturn because there's no defense documents that were presented. You will hear testimony from Ms. Jett that in fact she had a relationship with her father. There was intention. This wasn't a fraudulent act. And the evidence will show that he signed documents to properly transfer the house into his name and her name as joint tenants. And the purpose of that was because he wanted to take care of his daughter. She didn't defraud anybody because she was paid for all the mortgage, she paid the mortgage payment, paying the insurance payments. The water bill is in her name. The Republic Services bill is in her name. Everything's in her name to make sure it gets paid, make sure that they're both protected. And I think if you keep the open mind and you look back, what's the relationship between the father and the daughter, you're going to realize that there has been a travesty here and harming her more by taking away her ability to have a livelihood is just propounding the problems.
Thank you.
Thank you. Thank you very much. Phil Super Record. I'd like, as the division's case in chief, to call investigator Shannon Goddard.
Look is running.
See,
They were repeated.
Are you ready to be sworn in?
Yes.
Excuse me.
no, I'm sorry.
Thank you.
They're handing her a document, book I've never seen. I don't have it, so I need a copy of the book.
Mr. Seuss, can you explain what that book is? Open.
Yes. So the book in front of investigator Goddard that has the green cover, that would be the division's exhibits that they served onto Ms. Jett when they filed the formal complaint. These stamps are NRED 1 through 232. The binder with the orange cover is respondents' exhibits. I believe that they were provided by Ms. Jett's attorneys to the division sometime last week. And those would be the respondents' exhibits.
Do you have a copy of the exhibits for that?
It's in the computer there.
We have a copy of it.
Typically, you.
Yeah.
Whatever.
You're not being.
If you want,
different.
yeah, it was sent
One,
to
two,
the
or
respondents, so, along with all the complaints, notice of obligation to respond, and all of the exhibits will be sent in the complaint.
It's been a long time since I've had one of these, but normally exchange, so everybody's got all of
Is
these.
that in the court of law?
I don't.
That's in the court of law.
Oh, no, I understand. Of course, no, and
Oh,
thank you. I haven't done an NRED for some period. The ones I've done before, you actually got a binder, and so I will go forward.
But we haven't done it here in
Okay.
a long time. and it's
Probably since COVID. I
So
imagine.
that's like since 2020. So maybe we need to pick that up again, but haven't done it. since 2020.
Responding.
Yeah.
A binder?
Wait,
She would have been sent, how did you send it?
Amy Reverend for the record, they were sent certified mail to Karina, and then I had emailed, Sir Fluff
Mhm.
to make sure that you had received all those documents, and I got a confirmation, yes.
do have everything. You could have printed it, right?
We could, yes.
Okay. Do you know when that was sent?
Sent days before the November.
30 days before our November 4th meetings, they were sent.
There's plenty of time to print.
No, it's just
I get what you're saying. I understand. You got the
old dog, new tricks.
I know, I
A
understand.
lot easier with paper for me, but
I am a paper person too, but
Okay.
you do have them and you're in possession for a while. So I want to make that clear again. This is educational.
All right. With that said, I believe.
I'm going to swear.
Yes, please.
I'm at the point of swearing in. That's. No, you don't. Thank you. Raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Can you, for the record, please state your full name and spell your last name for the record?
Shannon Goddard, Goddard.
Thank you. What's your current occupation?
Compliance audit investigator too,
How long have you been in that role?
4 years.
That's with the division?
Yes.
What are the job duties of a compliance officer too?
Answering public questions by phone and walk-ins, as well as investigating case assigned by the chief investigator.
In this case, 2024-680, this was assigned to you by the chief investigator?
This was assigned by Chief Jan Holly.
Are you familiar with the documents in this case that have been submitted in support of the formal complaint? A state stamped and read 0001 through 032. 323.
Yes, I am.
And is that a printed copy in front of you with the green cover?
Yes.
You turn to Exhibit 1 entitled NRED, which goes from date stamp 1 through 35.
Okay.
Flip through that real quick if you would, and
Okay.
if you could generally describe what those documents consist of.
These are all the division documents, communications, original complaint, communication with complainant and Miss Jet. So anything that came from me out regarding the investigation.
So the division's own generated.
Correct.
Turn next to Exhibit B. There should be a couple of pages, Exhibit B, starting from date stamp 36 through 292. That's a lot to put thumb through, but you could try to do that. I'm going to ask you the same question. You could generally describe what those documents consist of. And I'll note that Exhibit B is entitled complaint.
So 36 through 292 looks like all the documents submitted by the complainant.
And the complaint in this case would be Yvette Swanbaum, correct?
Correct.
Turn next to Exhibit C, starting from Bates number 293 through 319.
293?
293. 319.
Okay.
Can you explain, well, first of all, I guess that's the respondent's documents, correct?
Correct.
And can you explain generally what those documents consist of?
This is response from Miss Jet and any emails, correspondence, and any supporting documents she submitted.
And lastly, turn to Exhibit D. I think it starts from Bates 320 and it goes through 323.
Okay.
What's that?
This is communication with Bob Hamrick, who was the broker at the time the complaint was received.
So you reached out to Mr. Hamrick during the course of your investigation?
Yes, that's who Miss Jet was employed with at the time of the complaint was filed.
Would there have been if you received a response from Mr. Hamrick, would that have been included in this within your notes?
Yes, he did respond that he acknowledged it. that he doesn't have any further knowledge because it didn't happen at the time that she was employed. The transaction did not occur during the time of that employment.
Would it be fair to say that the documents within that binder comprise of your investigation documents in this matter?
Yes.
With that, the division would like to move for exhibits A through D to be admitted to evidence.
So
Thank you. Now, investigator Goddard, could you please turn to NRED 2? And come through that through NRED 5.
What was the date? 2 through 5. 2 to 5?
2.
Oh, 2 through 5.
2, 5.
I see what you're saying.
So here we're looking at NRED dates 2 through 5. Could you just explain general terms what these documents comprise of?
It's just their divisions, evidence as far as where the licensure was, so where she was licensed at the time and who her broker was at the time,
So we have
license history.
license history for Ms. Jett on page 3, for Mr. Hamrick on page 4, and it appears to be an updated license history for Ms. Jett on page 5, correct?
Correct.
Turning to NRED 4. That document, does it indicate where respondent Jett was working as a salesperson during the time periods relative to this complaint?
Yes, it does.
And who would that be?
At the time the complaint was filed, it was Mr. Hamrick. And the previous one was the brokerage was closed.
Let's turn to NRED 320. Very bad.
Okay.
We had already alluded to this previously, but just to confirm, this is communications that you had with broker Hamrick, correct?
Correct, on 321.
Is your understanding that broker Hamrick would be present today or somebody in his stead?
Being that he's not the current broker, she has moved brokerages again. I believe the division submitted to Joseph Scott, which is Keller Williams VIP, where she's currently licensed.
Okay. Thank you. Let's turn to the complaints documents now, starting with NRED 37.
Okay.
So that appears to be an email from, well, it states Chris Swanbaum in the front field, but it is Yvette Swanbaum if we read the emails further on. That indicates that attaches complaints and court documents for Karina Jett. Let's turn to the next page, 38 and 39. Take a quick look through those.
There.
What, can you explain to the commission who Yvette Swanbaum was and what her allegations against Ms. Jett comprised?
She claims that she is the granddaughter of Mr. Mickles, Peter Mickles Gillis Sr. And she is alleging that Miss Jett and Mr. Mickles went into a transaction as he trusted her as a real estate licensee to purchase a home, assuming as an investment so he could live in the home, because his current situation with his girlfriend was not going to work out, so he needed a place to live. And she was claiming elder abuse, that Miss Jett took advantage of him based on his situation, and that she never allowed him to actually live in the home after the home closed, that the doors were locked and he was locked out of the home even 2 years after the closing of the purchase. And it further talked about the Supreme Court ruling that was appealed based on the original district court findings in the original case that I believe it was Peter McCullough Senior took his daughter to court, Miss Jett, in the district court case.
So on page 38, there's a line at the bottom says, I declare the penalty of perjury under the laws of the state of Nevada that the foregoing attached statement consisting of 48 pages is true and correct. What's your recollection of what the other 46 pages contain?
It's regarding the district court case that took place.
I don't, and I apologize. I should kind of object here. This is all hearsay now. Ms. Swanbaum is here to testify. That's fine.
Sorry, can't.
I'm sorry. Again, I apologize. This is hearsay as to Ms. Swanbaum. She needs to testify for herself.
And so the division's response is that this is an administrative hearing and rules of evidence are relaxed, and the investigator is able to testify regarding the context of her investigation. So it's the division's position that does not need to testify because hearsay evidence is able to be disabused, and you all can assign the weight of the evidence.
May I ask her just a question very quickly?
You will ask her a question when it's your,
It's called voir dire, if I can ask about this issue.
but we're not in a court of law, and I'm just real naive. You're taking me down a path that I'm not ready for. So
I understand.
may I ask you not to, if you could wait? And also, we took a lot of hearsay in your opening statement of hearsay of father and what was said and whatever. So, and nobody objected. So I just want to throw that as my personal opinion. Thank you, Mr. Sue.
But opening statements are not evidence and you can have.
I
hearsay.
understand.
Okay.
Oh, we're not going to debate. Are we?
Okay.
Thank you.
Yes, sorry, I believe there may be an objection pending still.
Oh, you're waiting for me to say?
Yes, ma'am.
You're objecting to it, and I'm saying it's over.
The right to voir dire is over. Okay, thank you.
No, did I not? You threw that in and I asked you.
I believe the objection was pending hearsay. So
And,
the objection was regarding the hearsay of the nature of these documents.
Is it not overruled? Because I'm saying I object to what he's saying. I'm not going to go with what he's saying. What is it?
Okay, that's fine. I believe it may have been two part. First, he was objecting to Swanbaum's documents being hearsay, and then second, he was asking for the voir dire, and you are overruling both.
Sure.
Okay.
Sorry, let me collect my thoughts.
I'm with you.
Let's turn to in red 61.
Okay.
Take a look at that letter and then tell me what your understanding is of that.
This is a letter written by Chief Jan Hawley on September 25th, 2023, a few days after receiving the complaint stating that it was a Miss Jett, if she received a criminal felony conviction, that she needed to let us know about that, and that at this time it was a legal matter and that the division would not be investigating.
So what changed? What's your understanding of what changed between September 25th, 2023 and when the division actually did initiate the investigation?
It appears we got new additional evidence based on what has been submitted and some handwritten things on the actual complaint regarding the Supreme Court case. And as I understand through conversations with Mr. Hawley previously, that our DAGs were consulted and approve this to be proceeded as an investigation.
Turn to NRED 168.
Okay.
If you could from 168 through 176 for me, really.
Okay.
In general terms, can you describe what this document is?
It's a decision and order from a bench trial on July 16th of 2020. I'm not sure 20, what year that is, actually, it's cut off.
I'll note, there's a file stamp electronically filed on September 15th of 2021.
21, okay, that's the thing. In district court case, between Peter McEllis and Karina Jett as the defendant.
And just so we're clear, this is a document located within Exhibit C that would be complainant's documents, correct?
Correct.
Now, this bench trial order, did you review this in the course of your investigation?
I did.
Did your investigation take into account this bench trial order, district court?
Yes, it did.
At this time, the division would like to move the commission to take administrative notice of the district court's order pursuant to NRS 233B.123 subsection D of judicially cognizable facts and of generally recognized technical effectiveness. And I don't know if you want to hear from opposing counsel on that, but
We can't water or so.
I'm sorry, I couldn't hear you. What
I
was that?
said,
I couldn't hear you.
no, what I said was apparently you can't voir dire, and so no, I have no objection.
no objection to the
Thank you.
administrative notice. Okay. And I guess I just need the indication from the commission if they are willing to take administrative notice of this situation. Yes, thank you. Okay, so at this point, I'm going to ask Investigator Goddard a series of questions to kind of set the scene as far as the factual allegations. Let's turn again to that 168 page. Can you explain what this Peter McEllis that's named as a defendant, initially, who was that sued in this case?
Well, Ms. Jett was the defendant. Peter McEllis was the plaintiff.
But it was a father who sued?
So the father is suing the daughter, yes.
And what, do you have, could you explain just in general terms, what was he seeking in that district court? But let me turn to refresh your memory. Let's look at the bottom of page 170.
Okay.
There we have list of the legal issues as identified by the court this order. The first would be for a rescission of deed for misrepresentation of fraud, correct?
Correct.
Then let's turn to the bottom of page 172.
Okay.
And there it notes that McEllis was looking for double damages for elder abuse pursuant to NRS 41.01395, correct?
That's correct.
So those would be what the court was ruling on in this one. That comport with your recollection of this complaint?
We object to this because now it's calling for a legal conclusion that she is not a lawyer. She has no background. You know what the document speaks for itself.
Overruled.
And when I'm asking you these questions, this is based on your investigation and your review of these documents, not necessarily assuming that you're an attorney. Do you understand that?
That is correct. I mean, I'm based on just reading basic English. I'm reading that what you're saying is correct.
Now, what's your understanding regarding the terms of VA loans, in terms of whether somebody can rent out that property once they secure it?
My understanding of VA loans, is pretty standard. It needs and it stated on the documents, the lender documents, that a VA loan is only for an owner occupied property. And it states in these documents here that he had anticipated living in the home along with other extra rooms being rented out for poker players that come into town. But he would be living in the home, and the loan was based strictly on an owner.
Is your understanding whether Mr. Nicholas ever lived in that home?
It appears in all my evidence that he never lived in the home, never even had access to the home for 2 years. He tried to seek access to the home.
And when you say he didn't have access to the home, what happened?
I was evidence that he was locked out, never given keys, and forced to, I believe, stay living with his girlfriend.
Now this requirement under a VA loan that the loan applicant should live in the home as a personal home. That's common knowledge among real estate professionals. Is that your understanding?
Yes, I would think so. Yeah, it's lender rules. Yes.
Do you have any understanding regarding the potential impact of a VA loan applicant applies for said loan and then does not actually reside in the residence afterwards?
I believe it could be foreclosed on.
So would that be based on so a rescission of the VA loan?
It could be rescinded based on fraudulent circumstances.
Would criminal charges be a possibility?
Absolutely.
Well beyond the scope of this.
Excuse me, I have to my right a very smart person. She's the attorney for open meeting law.
Okay.
And I checked with her, and you could correct me because I don't remember the fancy word of or whatever it was. Or do. But we don't have to use it. This is an open meeting law. We're under it. We're following all guidelines. You're getting very upset. Sitting there making faces, this, that. Let's just be respectful to each other.
I
It is
apologize.
distracting to me. You're right in front of me.
I apologize.
Thank you so much.
So there was a pending objection regarding
But let me just interrupt and ask one question. Are there any rules of evidence that apply in open meeting?
He's asking.
Oh, you're asking, so yes, Stephanie Aiken Goodman for the record. Yes, they're, like Bill had said, though, they're more loose than
I
they would be
understand.
with criminal or civil.
I understand the loose, but I just objected to the fact that she's offering a legal conclusion. That she's not an attorney and the document speaks for itself, and I was overruled. I just want to know where do we break the line between no rules of evidence and loosely construed?
I may be heard. Phil Super, the record. I believe that the evidence, the rules of evidence as pertaining to administrative hearings is covered under 645 and 233B. Essentially, as far as the disclosure of of that evidence. Now, as far as the scope of the questioning of, say, an investigator, I'm trying to align my questions within the scope of what the investigator might have reviewed. I'm not trying to ask for her opinions as an attorney. She's not an attorney, but that's my position as far as whether or not she's making legal conclusions. So that's the division's position on that objection. I don't know if it's already been ruled upon, but I'll put that on.
Thank you. Anything further?
I don't have an answer, but sure, it's fine.
I think you have an answer. You might not always get an answer that you agree with.
No, I'm trying to figure out where there are rules of evidence. You're saying they're loosely construed. That's great. At what point do they no longer apply versus are they loosely construed? That's all I'm trying to figure out. And I'm not trying to make faces. I'm just frustrated at the distinction between that line.
I'm not sure how we could assist you in that or educate in that.
Well, I don't want to make,
We're in the middle of.
I don't
So
want
we'll
to,
try to answer. The best.
I don't want to keep interrupting and objecting I had some clarity about where the line was, I wouldn't see that. And the faces are, I don't know whether to object or not, because there are clearly statements were made in an ordinary hearing would be objection in trial, at a court hearing.
But you knew you were coming to an open.
Absolutely. I just
Okay.
tried to figure out where the distinction
Okay.
is.
And hopefully it'll work its way out real soon.
I got it. Phil Sue for record. One more addition. Let me refer the commission and my opposing colleague to NAC 645.845, Rules of Evidence, Formality of Proceedings. That regulation indicates there's 5 subparts. 1, in conducting any investigation, inquiry, or hearing, the commission, its officers, and the employees of the division are not bound by the technical rules of evidence, and any informality in proceeding or in the manner of taking it testimony does not invalidate any order, decision, rule, or regulation made, approved, or confirmed by the commission. The rules of evidence of courts of this state will be followed generally, but may be relaxed at the discretion of the commission if deviation from the technical rules of evidence will aid in determining the facts. So section 2 says, any evidence offered at hearing must be material and relevant to the issues of hearing. Number 3 says, the commission may exclude inadmissible, incompetent, repetitious, or irrelevant evidence or order that presentation of that evidence be discontinued. Number 4 says, a party who objects to the introduction of evidence shall briefly state the grounds of the objection at the time the evidence is offered. The party who offers the evidence may present a rebuttal argument to the objection. And lastly, subsection 5 states with 3 subparts. If an objection is made to the admissibility of evidence, the commission may A, note the objection and admit the evidence, B, sustain the objection and refuse to admit the evidence, or C, receive the evidence subject to a subsequent ruling by the commission. So I hope that answers opposing counsel's question regarding the applicability of the rules of evidence here.
Did it help?
Yeah.
No?
Fine.
Thank you, Phil. Find me where we were, you were questioning.
Yes, it was.
Thank you.
Let's sure have you turn Shannon to iterate 172. Can you read for yourself that middle paragraph, starting from here the evidence supports?
Here the evidence supports finding that Peter relied solely on Karina's advice when purchasing the house and adding her to the deed in order to avoid probate. Thus, they were in a confidential relationship, not merely that of a parent and child. Peter believed Karina would care for him and that rental of the extra rooms would generate income to cover the mortgage. Karina intentionally withheld her real intentions when she induced Peter to add her to the deed. Karina paid no consideration to acquire the property. However, she may have a claim against the estate to extend she made mortgage payments or covered the cost of homes. Continue.
If you could, that italicized Morgalia is a case citation. Yes, and you continue just through the rest of that sentence.
Okay, Morgalia allows such a claim on the part of the defendant in an action for rescission. However, there is no evidence in the record upon which to base an award in this matter. Therefore, Peter's estate is entitled to rescission of the deed.
Now, this is a court's finding on that particular claim.
That's correct.
That play into your investigation, your conclusions thereof?
Yes, because this was an order from the court.
How about, let's turn to page 174.
Okay.
You could read from line 11, Peter was over the age of 65.
Peter was over the age of 65, parentheses, at the time of his death in 2018, he was 91 years old. And Karina exercised undue influence and exploited her position as his daughter to place her name on the deed. Continue.
Please, all the way through the end of that.
Okay. Peter is entitled to recovery under the provisions of elder abuse statute. See NRS 41.1395. Karina was not exercising the normal influence of a child, as she promised her father that the property would be his home and would also provide income to cover the cost of ownership. Karina had no intention of allowing her father access to the home he purchased with a $15,000 down payment. As Peter did not have other disposable assets, he was unable to purchase another home for his final years.
Is it your understanding that this finding from the court corroborated supported the court's finding of elder abuse and double damages in this case?
Based on this document of the terms of elder abuse, but they did fine her for $30,000 for elder abuse, which is in the next paragraph.
But the factual determinations within this paragraph, as far as Karina not exercising normal influence of a child, but and of her not intending to allow her father to access the home that he had purchased, is that corroborated separately by your investigation and by the documents you've obtained there?
Yes, I would say so.
Can we turn to turn to page 157.
Okay.
Can you look from 157 through 159?
Okay.
What's this document?
This is a grant bargain and sale deed dated
57,
May 1st, 2015.
Sorry, please go ahead.
The grant bargain and sale deed dated 5/1 of 2015 grants Peter McGillis as an unmarried man and Karina Jett, a married woman, as joint tenants with right of survivorship.
So they were joint tenants. They own the property jointly.
Correct.
Let's turn to 189, please. And
189?
Yeah.
I'm sorry, did you say? And
189.
And red 189.
thank you.
Okay.
I'm sorry. Am I saying it's the wrong page? Am I? But not 189. Now let's turn to 72.
Okay.
Go ahead and take a look over this and the next page. Finish reviewing that.
Okay.
What is this even?
This is an email coming from Chris Swanbaum that is actually signed by Yvette Swanbaum. And this is in response to some questions I had asked her to clarify in my investigation. That she is stating that, just as a long story short, that her grandfather purchased the home on April 17, 2015. You want me to summarize this, correct?
Yeah, somebody be fine.
And once the home closed on that day, she changed the locks and locked him out of his VA loan home he purchased. He called to tell me she locked him out. I found the recorded deed and he never saw the 100%. It was blank. I called Karina to ask her why she changed the locks and not to let him live in his own home. And she told me verbatim, it's my house. I will rent it out and no one wants to live with an all caps old man. My grandfather, Peter McGillis, begged her for over a year to give him back his house and she refused. And she states he passed away on October 19, 2018. And we had, we went to court. She said they went to Supreme Court and they won again as the case was paid 30 grand for elder abuse. She never gave my grandfather a dime of profits over the mortgage amount of $1,570. And she stopped paying the mortgage the day he passed away in 2018. He continued to pay until we continued to pay, until we were finally able to sell the home 5/22/2022. And the money is held with the estate attorney until the Supreme Court decision. They lost $62,350 of mortgage payments that we did not collect from Karina. We also lost $27,000 in attorney's fees from Supreme Court attorney we had to hire. It also states that Karina, the daughter of Peter McGillis, was paid commission for the sale to my grandfather, which she told him she would not charge her own father's commissions. That's about it.
And that was a document that you obtained from Brett Swanbaum in the course of your investigation, separate and apart from any district court.
Correct. Those are questions I asked as a follow-up to the evidence I received.
Now let's turn to NRED 0269.
Okay.
I don't need you to read through all of it, but I'll represent to you that starting from 0269 through 0286 is all one and the same document. Can you explain in general terms what that document is?
This is the order of affirmation filed on January 30th of 2024.
And that from Court of Appeal affirming the district court ruling 3 years after district.
Correct.
Did you obtain this document in the course of your investigation?
I believe she sent this to me after I sent that email. So as additional documents, yes.
So this was part of the complainant portion of the file.
Correct.
Now the essentially the respondent lost this appeal as well. Right?
That's correct.
And so in sum, your investigation, plus the court documents, what does all that in total mean for you as far as your determinations of whether or not there were findings regarding fraud and inducement or misrepresentations by the respondent?
It brings concerns that initially a VA loan was taken upon that the property was going to be occupied and rented out for a profit for the father to help him out. And then we're getting evidence here that he was not able to live in the home. So those circumstances that this was ruled as a fraudulent deed based on those situations that he did not occupy the home. He was not allowed to live in the home, and that she was renting out the home to other occupants and paying the mortgage for quite some time, but then discontinued paying the mortgage. But he was never able to live in a home he bought himself with his VA benefits.
Thank you. Now, one final bit before we conclude. Let's turn to page 297.
Okay.
You could review these two pages.
Affidavit from Miss Jett, based on my request to respond to the complaint.
And if you could summarize what this affidavit was and how it impacted your investigation.
Well, it basically responds to each claim as to her side with the fact and her claim. So there's several responses here. You summarize it.
Yeah.
I can summarize kind of each claim. So
I
the
guess
first claim was that he was coerced to buying the home. She states that my dad wanted to live on his own and break up with his girlfriend. After he purchased the home, he decided to rent it once they got reconciled. I am the only realtor in the family. I sought the best financing for him as a veteran and helped him purchase the home.
pause there. That first claim, this is a VA loan, and we were established that there's an understanding that the person, that loan applicant is the one who has to reside in that home.
Correct, which is he was the only applicant
So
on the VA loan.
to the extent that this jet here represents that he has chosen to go and live with his girlfriend, has it been one of her professional responsibilities to let him know what his obligations were under that loan?
Absolutely.
Go ahead
He
and
lose his home if he wasn't living there and the lender found out.
um, please go ahead and just.
So then he was added, she stated, he added me as a joint tenant with right of survivorship as I was the only one he trusted and knew would be working in his best interest. Miss Swanson was not a witness to or a party to any of the dealings with me and my father. She is not an executor or witness to any of the transactions. Then she goes further to the claim of I rented it out with approval of my father. With my dad's approval, we rented the house out for profit. He had me handle the paperwork. I paid the bills, the mortgage, and it was a joint venture. Again, I'm just summarizing. The claim of elder abuse, she stated, if my relationship was strained with my dad, or if he felt abused in any way, why would he name me as not anyone else in the family as the medical proxy? I love my father very much. My father passed away in 2018. His children from another marriage did not know about the home purchase until right before he brought a lawsuit against me with absurd claims. Another claim, a hearing took place and all issues were litigated, resulting in a judgment of $30,000 against me. I was advised by counsel not to appear at the hearing. My rebuttal evidence to Ms. Swanbaum's lawsuit was never heard, never litigated. The attorney who advised that nothing was being presented that day, so I did not need to appear, was wrong. Claim was I took in $180,000 in rental income from 2015 to 2021 and did not give any to Ms. Swanbaum. Ms. Swanbaum was not legally entitled to any monies from the house my father and I held in joint tenants. Claim was I was not named in the will, so that shows he wanted me excluded from his assets. She states the fact was the will referred to my dad's other children and grandchildren. He always planned to my inheritance to be covered by our property, which was joint tenancy with right of survivorship, would pass to me without going through probate. The property would not be a part of my dad's estate at time of his death. That concludes the summary, and this was dated August 30th of 2024.
Let's, you could turn to page 20, NRED 20. Sorry for making you flip through this, but the way we organized it, NRED documents that, one section and then respondents documents in another. But 20, I think that, correct me if I'm wrong, but isn't this the request for information that you sent that precipitated, Ms. Jett's response?
That's correct.
So as far as how, she's laying out the charges in the responding document, that's nowhere found in the R5 that you submitted. So how she's construed the statement of fact by Ms. Swanbaum.
That's correct.
Does she make any representations regarding whether she continued to make the mortgage payments after her father passed?
I do not recall anything in Ms. Jett's statement, just in Swanbaum stating that she stopped making payments after his death.
And is it fair to say that you took Ms. Jett's response to, into consideration in the course of your investigation?
Yes, absolutely.
of Did you turn to respondents, I'm sorry, no. In summary, does your review of the evidence collected in this case, does it comport to, does it match what the district court had regarding findings of fraudulent inducements and intentional or negligent misrepresentation?
I believe it does.
Anything else you want to add for the commission's knowledge they should take into consideration or as far as your investigation?
That I can think of.
And certainly the commissioners will have the opportunity to ask you questions directly if you have any, but I will, at this point, thank you for your time and estimates.
Thank you. This time it is cross-examination, but I'm going to ask if we take like a 5-minute break. Let's do a 10-minute break.
Thank you.
It's been 2 hours. sitting here. This is really-
I'm in, okay. Ah, but the one that said the organizer is, her name is, hello, is anyone there that can hear me? Hello, anyone there that can hear me?
Yes, I can hear you.
I am supposed to be getting CE credit for this, but I don't know if I am. Is there any way to confirm that? Oh,
I believe they said when you signed in, you automatically were logged in to get CE.
oh,
But I'm
perfect.
not
Thank you so much.
positive. Just send something through chat.
I don't have a chat option on here. I was going to send it to Bailey Valdez, the organizer, but I don't have an option to chat with her, with anyone for that matter.
Registration email, there's a link.
Maybe in the email, send it through the email.
Okay, I will. Thank you, Nikki. Oh, no. Who am I speaking with? Yeah, Nikki. Thank you, Nikki.
You're gonna have like about 1,000 of those back to the office, so.
I realize
You take.
I am grounded. I was thinking like, they said I don't know. Says that. Or anything.
Just to be fair.
I don't. Yeah, right. I don't even know how to, don't even know how to tie it like you did.
Are we all ready? We're gonna start again, and I think we left off cross-examination, which is fine. Thank you.
Ms. Goddard, my name is Michael Van. I'm here on behalf of Ms. Jett. And I'm
Excuse
gonna-
me 1 second. They stopped me, 2 people to tell me they can't hear in the back, even me. So I don't know what the problem.
It's the air.
It's the vents.
Thank you for blaming somebody other than.
I'm gonna pass it around because we're gonna donate to get new speakers in here.
Yeah, sure.
Talk through a megaphone.
So speak closer.
Except, you know, like, big one.
Ms. Goddard, my name is Michael Van. I represent Ms. Jett. I'm going to ask some questions here and try to get some clarity as well. So this real estate transaction was in 2015, correct?
Correct.
Let me back up before I get there. So you're a compliance auditor. What does that, are you an investigator or an auditor?
Both. Depends on what kind of case we have, but we do have auditor financial audits and or compliance audits. So we are trained for both.
So as part of your training as an investigator, is that why you were called on or assigned this case as an investigator or as an auditor or both?
We are all qualified to handle any case. I'm sure our chief assigns them based on what they feel, what he felt at the time who would be best at certain cases, but other than that, they're randomly assigned.
So what was your role in this particular case? As an auditor or as an investigator?
I'm more as an investigator because we are not required to, there wasn't much financial findings necessarily in this. So be more of an investigator, but for both roles are, handled in any investigation, just whatever is needed.
What are your responsibilities as an investigator?
They run the gamut. I review all the documents that come in. I examine both sides. I get responses from both sides. If needed, I will interview in person or over the phone to get additional documents. As such, I did with, I believe we reached out to Ms. Jett and to the complainant to get further discussion. If I need additional documents, I will request those. We have authorization to subpoena records if needed, and or get court documents if needed. If I had further clarification or needed court documents, I could get those as well. And then we evaluate the evidence based on, and in our NRS, we are able to use court documents as investigation to determine findings, because as I am not an attorney, I have to be based on legal findings from the courts to make determination based on our statutes of NRS 645.
Okay. Who did you interview? Who did you personally have conversations with? Not electronic conversations. Who did you have conversations with in this case?
Miss Swanbaum for sure. I do not believe Miss Jett and I spoke over the phone, just via email.
So you never interviewed the defendant?
I do not believe so in person. In person or an email, or excuse me, over the phone.
I think that would be important as an investigator to hear the other side.
In this case, I didn't feel it was necessary because there is a lot of, he said, she said. That's why I do bring it to a hearing for the defendant to allow them to speak on their own behalf in front of the commission board, because ultimately I'm not going to be making the decision, they are.
So in this case, we have a she said between Ms. Swanbaum and Ms. Jett And you listened to one she said, but not the other she said.
Well, in a lot of the findings, in this particular case were based on the court hearing. The court hearing and the appeals, and the deeds themselves and the law based on VA loans, et cetera.
Okay. In the court hearing, did it strike you? How familiar are you with court hearings?
I don't necessarily have a legal background as far as court hearings, and just being able to read and analyze. I always can reach out to my DAGs for further clarification. And in this case, I did reach out to a few times to our DAG to clarify that I was interpreting things correctly.
Did it seem odd to you then in that court hearing where it says Jet was not present at trial and the attorney did not object to the admission of the complaint or proffer any witness or testimony or evidence on Jet's behalf? Did that seem odd to you?
I did read that, and it's not required to have an attorney for any hearing here or a criminal hearing. That's not.
This was not a criminal hearing.
No, it was not. So it's not required to have an attorney. So it is odd. I mean, it was that's odd, yes, but it's not required to have an attorney.
It's not required to have an attorney at a trial.
No, you can represent yourself if you wish. But yes, I did find it odd that she didn't have an attorney.
Did you not question her about that?
The determination was made from the court, so I went off of that determination.
If I may, just object, just wanted to clarify, I believe that there might have been the statement regarding the order. The order states that she did not appear, but she was represented by an attorney. Because it seems like this other question is going in a different direction.
I'm getting there.
Okay.
So she had an attorney, but she wasn't present, correct?
She was not present. The attorney was present for her. Yes.
Correct. And you read the line that said, that I just read from, that there was no evidence presented in her defense. Did that seem odd to you?
Again, I said it did seem odd.
Did that not raise at least enough flag for you to say, you know what, I probably ought to talk to her?
Well, I did ask for her response, which she would have every opportunity to present her evidence and or attorney's evidence at that time. So I go based on what I gave her every opportunity to present 500 pages if she wanted to.
Okay. Was Miss Swambaugh a party to the underlying case?
No, she was not.
She a witness at the underlying case?
I would consider her a witness because she's part of the family.
Was she called as a witness at the underlying case?
And
No.
at this point, I'm going to
Not that I
object.
know of.
At this point, I'm going to object. If you could just hold your response. I'm going to object because this is starting to relitigate the underlying district court case.
Right.
Something that the investigator was not herself privy to. That's not true. It's relevant.
House was purchased in 2015, correct?
Correct.
And the underlying complaint was filed months before Mr. Michaelis passed away, correct?
Complaint to us?
No, the complaint to the underlying civil complaint.
I don't know. You'd have to reference when that complaint was actually filed based on, I'd have to look at documents on that.
The NRED complaint was filed in 2023, so 8 years after the purchase. Did that seem strange to you?
It did, and I did question Ms. Swanbaum on that, and that's in the evidence or in
Okay.
emails.
And what was her response as to why?
I'd have to reference the exact email, but I believe she just said that it one, financial, it was very costly. And two, I believe that they were trying to just be able to get access to the house, and they were giving her opportunity to do that, to allow Peter Senior to have access to the home. She didn't give me a direct answer, but that's what I recall based on the email. She did, like I said, I believe she wrote me an email in writing with that response. But yes, I thought that was very odd that it took so long to get to us.
How much does it cost to have NRED investigate?
No, she was referring to the cost of suing Miss Jet.
Okay. That was not my question. I apologize. Let me restate. There was a purchase in 2015. the NRED complaint was filed in 2023. Does that cost anything?
It does if it goes to hearing, but not to file the complaint.
Okay. So in 2023, 8 years later, they filed their first complaint, which was denied. And then a year after that, it was approved, correct?
It was denied by, what do you mean by denied?
NRED said they weren't going to go forward. And then then the AG came back later and said, yeah, go ahead and go forward.
Yeah, but that wasn't 2 years later.
It was a year later.
Excuse me.
I don't recall
I
it being a
need
year
to-
later.
I
I'd
need
have to look at that.
Excuse me one second. It would be better if you would give us the documents and not so that we could look at what you're referencing, because we're doing a lot of hearsay here. And I want to reference documents that you're saying 2 years, 1 year.
Yeah, in this situation, I'd have to see those years because I believe it was much closer than we decided to investigate the case when the complaint came in.
All right.
We wouldn't have waited a year.
But you waited but there's 8 years between the sale and the original complaint. Correct?
Yes, and as I understand our statute, we have 5 years from the date of closure of the case. So any case, which would have been the Supreme Court case, which I believe was in 2024.
Okay, I'm not talking about the civil case.
But it was 8 years after we got the complaint, yes,
And that seemed odd to you.
it did.
Now, you said that they wouldn't let Mr. Michaelis in the house, correct?
Correct.
Did you ask them he was on title, correct?
Correct.
Did you ask them for any police reports where they had gone in to change locks on the house?
Ask Ms. Swanbaum?
Yeah.
No, I did not.
Is there any evidence whatsoever? Did she provide you any evidence that he was denied access to the house other than her saying he was denied access to the house?
Other than there was mail, I believe I saw in the evidence that there was mail going to the girlfriend's house for several years afterwards, which would indicate that,
That he forwarded the mail.
continued to have mail going to that address.
Okay, so he forwarded the mail. Is there any evidence that he was denied access to the house?
I don't have specific evidence, no.
Okay. Is there any evidence of a police report of any type of violence or anything that she was denying him the ability to go into the house?
Not unless it was brought up in district court, in the
Okay.
district court hearing.
From your understanding, if two people are on title to the house, can either one of them get a locksmith out there and rekey the house?
Either one, either owners would be able to.
Okay. Do you know if that ever occurred?
If they change the locks to the home,
They even asked to change the lock to the home.
I don't recall that.
Does it appear then, based upon the evidence, not upon commentary, not upon statements, that he was ever denied access to the home, other than Ms. Swanbaum's statement?
And the court evidence, no.
There's a court finding, correct. And we've already established that Ms. Jett was not there.
Correct.
And you read that transcript that she was not there. But is there any empirical evidence other than statements in that court ruling? Because obviously the court didn't go out and,
I've stated no.
okay. Now you talked about the broker, Ms. Jett's broker. Did you reach out to her broker at the time of this transaction? Ask him for any issue.
Time of the brokerage was closed and I was unable to locate him.
Okay. Did you do a disciplinary investigation as to any prior disciplinary actions that she'd had?
To see if Ms. Jett had any prior disciplinary actions. We generally don't do that. It sometimes comes up in hearing, but we take every case as that case is separate from another. So it's not like a criminal hearing where you can, bring that in as substantial evidence. We take the hearing as or excuse me, the evidence for that particular investigation only.
Okay, so as you sit here today, you don't know if there's ever been any prior disciplinary actions against Ms. Jett.
I believe she was not disciplined prior, but it wouldn't necessarily be a part of my investigation, whether it would sway me one way or the other.
If you can turn to NRED 38.
Okay.
Okay, and 39.
The statement
Those-
of fact.
Yeah, those are the statements from Ms. Swanguam, correct?
Correct.
And that was the basis upon which you began your investigation.
Right.
Okay.
Based on what the case was open for.
Okay. If you look at, 39. The second line says she changed the locks on the house the day of closing and denied him entry or to live in his house. See that?
Hmm?
Is there anything to back that up other than just her statement?
The district court case accepted that.
Okay. When you talk about the VA issue, is it okay for someone to get a VA loan and rent out houses as long as he is living in the home as well?
I believe so, yes.
That's against VA?
No, as long as the person that got the funding for the home is living in the home, he can rent it to other people, as I understand it. But he himself has to live there.
All right. So if the intention was that he buy the house and rent out the other rooms as long as he stayed there, that would not be a violation of the VA loan.
Correct, as I understand it.
And had you interviewed Ms. Jett, would you have asked her that question? What his original intention was?
Wouldn't believe I needed to, because I had enough evidence to show that was the intention. She indicated that was the intention, as well as the complaint indicated the intention, as well as the court case, the order indicated that. So 3 different areas indicated that intention.
That was the intention. Okay. Expecting anyone. If you can go to NRED 168.
Okay, there?
This is the decision in order, correct?
Correct,
And this is the one where it says Karina Jett did not appear,
correct.
but was represented by counsel Anthony DiMartino.
Yes.
Did you talk to Mr. DiMartino?
No, I did not. Again, I relied on her to submit what documents she wants in support of her defense.
You can go to NRED 170. If you can read line 13 and the first word on line 14.
Other than Peter's initial $15,000 investment, there was no evidence about damages. Karina did not account.
That's fine, just that far. So did it occur to you that there was no evidence about damages, including the lockout, the denial of access to the house? There was no evidence of that in the court, in the underlying court case?
I don't believe that says anything about lockout. I'm not sure what they're referring to as far as damages, but that's not referencing the lockout, I don't believe.
All right, let me read it. Let me read it.
Excuse me, sir. I think this is outside her scope.
This is what she testified to.
Bill,
My understanding is that he is, as long as this, Mr. Michaels is limiting the scope of the testimony to the order itself, then that's.
Not litigating facts here.
It's possible. I think it's a matter of whether or not the commission wants to provide him with some latitude to discuss these details, but there is an element of relitigating the facts here. That is true. So that would.
I'm objecting to,
You
that's
are.
why I'm saying that. Relitigating facts. I'm going back to that case constantly when it pertains to certain things.
That's
So
true. That is the
So-
nature of this defense. So like,
How does it makes a decision, the board, the other commissioners?
the division would be, let me restate, the division objects to this line of questioning in that it does relitigate the underlying district court case and seeks facts that are not relevant to the disposition of the case that is currently before this commission. That's my.
Okay, so we don't have to do it, so same,
Yeah,
right?
okay. You just simply say sustainable.
I did say so.
I just want to be really clear.
Wait, let me check. Did you get that on the record for me? I know I was talking really low. Okay, go ahead. Sorry.
I just want to be really clear on this. I was asking a question about damages, which she testified to. She testified specifically to this line in this document on his direct examination. You then told me that I was going beyond the scope, which is not your position. It was his position to object. And then he then reworded the objection. Is that accurate? I just want to make
So
sure.
again, you're assuming in your conversation. I was to the attorney that is sitting right here to my right told me that you were going to that. So it was an attorney. It wasn't. So
So staff counsel is telling you that I'm going beyond rather than your attorney.
well, he did say,
I'm not.
No, after he reworded it after you did. I agree. But I just want to make
For the
very
record-
clear.
For the record, I'm not her attorney. I'm a prosecuting attorney in this matter. And if upon advice of commission counsel, separate from me, she raised, the commission chair wishes to raise that point. That's Lieutenant Bonds. And then if I wish to react to that, I believe that's also.
did that clarify it?
Not really, but okay. I have a question about damages and you're not allowing me to ask a question about damages that she
We
testified. to.
keep going over a case that you don't want other people to talk about at certain points. And now you want to talk about, we're reliving a case. And you're asking her to be an expert. Scope.
And
You should have objected then. if-
I
if-
did, and you overruled
Not on
on
that
this.
particular-
This
Not
one.
on this particular item.
one moment, what, sorry, Mr. Van, one question. What page are you on right now?
I'm on 170, line 13, and it says there was no evidence about damages.
Okay, so just point on that. I think the recitation wasn't to that particular line from my line of questioning. So as far as recitation of damages or what damages were being sought in this case, I think the testimony that I saw from Investigator Goddard pertained to the doubling of those damages. I think that was later on, the conclusion on page 174. It wasn't regarding the damages themselves. I've taken great care to avoid discussion of damages, discussion of rents, things that were not relevant necessarily to this. So I believe that that may be misrepresentation of the scope. My solicited testimony from Ms. Goddard as far as the damages. So I'll put that out there on the record.
Can I start asking questions?
Absolutely. Yeah, I'm waiting.
All right.
Go ahead.
Would locking somebody out of the house be considered damage?
Object that calls for a legal conclusion.
It's not a damage.
Almost.
Objection that calls for a legal conclusion.
Same.
Okay. Is it fair to say that on exhibit 170, it says there was no evidence about damages? other than the 15,000.
Yes, and I don't know what they're referencing about damages specifically there.
But it does say there's no evidence about damage.
That's what it says, yes.
Doesn't restrict it.
That's what it says.
And is it fair to say that you never had a conversation with Miss Jett about this allegation of lockout, or that he was ever given keys?
I had the conversation as I've gotten her response stating her opinion on what happened. So yes, she referenced that in her response that I read summarized earlier.
And did she reference that he did get the keys? You remember?
Excuse me? I didn't know.
Do you remember if she referenced whether he did get the keys?
I don't recall specifically. I'd have to go back to her response.
Let me. As you read on page 174, line, NRED 174, line 23 and 24, or the end of 23 to all of 24.
Yes.
Says, as Karina's actions were fraudulent, Peter is also entitled to his attorney's fees and costs of suit. You see that?
Yes.
Did you look at that and did you just assume that to be accurate, or did you look into the allegations of fraud?
That I will object to. It's not relevant to this case.
Sustained.
The allegation of fraud is not relevant to this case?
No, the second part of it about being entitled to attorney's fees or costs.
Okay, that's fair. Did you do any basis? Did you do anything to look? I'll withdraw that question. With regard to the first part of that sentence, as Karina's actions were fraudulent, what investigation did you take into the determination of her fraudulent activities?
Well, one, she was awarded, or she was assessed damages of $30,000 for elder abuse. So, obviously within the testimony of her attorney representing her, had to have some evidence of this, whether she showed up or not. He presented her evidence. So the court ruled that she was in fault of elder abuse. I felt it was fraudulent from the get-go, when you are allowing someone to, or excuse me, getting a loan for a VA loan to be living there. The father clearly identified, he was in testimony himself before he passed away, saying, I thought I was going to live here with not, excuse me, he didn't testify. I believe his son testified on his behalf. I have to clarify that. But that he was going to live there with other occupants. So he had never had any intention. So that from the get-go was, I felt was a fraudulent transaction based on a VA loan, using his benefits to get a VA loan for a home he never intended to live in.
You never interviewed the dad because he passed away, correct?
No, I did not.
So you don't know what the dad's intention.
I do based on the court documents, however. I read the entire court document.
You don't know what the dad's intentions were because the dad never testified, correct?
Correct.
You know what the court determined was the outcome, but not the intentions, correct?
Correct.
Okay. And your basis of that is based upon the son's testimony who inherited the house, correct?
Objection. This states the facts that were established, both in evidence and.
You based your testimony, or you based your understanding upon the son's testimony, correct?
I based it more. I can't answer that specifically. I did read within the evidence that what the intention was for him to live there And that would have been the only way a VA loan would have been approved if he himself were to be living there.
And
A VA loan would never been approved if that home was going to be rented and he was never living there, period.
and you don't, are you a mortgage broker?
No, but I have a lot of knowledge in that area, and that is, as the attorney said, pretty common knowledge that on a VA loan, and I did research that just to clarify my perception that it has to be owner occupied, and it states that on the document in this evidence.
Did you look at the loan, loan package?
That was definitely in there. Like, again, we'd have to reference documents. I can't go off everything in memory. There is a loan documents information in here, and it did specifically say that it was an owner occupied property.
And who filled that out?
I have to reference the documents. If you want to find it, I could look at it. I don't recall specifically. I mean, it was from the title company.
So it was, do you believe it was his intention to live there based upon the loan documents?
Yes. Otherwise, the loan would not have been approved unless it was fraudulent.
Okay, so the loan documents say his intention is to live there. It was approved. He got the loan, correct? Now, you also said something a second ago that you said that at the trial, her attorney presented her evidence, but you also earlier acknowledged that her attorney didn't present any evidence. Which of those two is it?
I made a mistake earlier. Her attorney did present on her behalf. She did not appear.
What did her attorney present on her behalf in her defense at the civil proceeding?
I'm gonna object here because this, again, this line of question is against trying to relitigate the details of the underlying case, which we're not here to stay.
No, can I just offer my side before it's sustained?
Sure.
Okay. She just testified to something, and I'm asking her to clarify what she just testified to. That's all. I'm just asking her to just testify or clarify what she testified to, not anything else.
Clarify your
Yeah, my rebuttal or my sewer rebuttal would be, she was simply responding to his questions. I don't think she provided any testimony regarding what evidence was or was not provided. That's apparent on the face of the document that, according to the district court, no evidence was provided by regarding that particular detail. But I don't know. I don't think
Counsel, now you're testing. I would like to test. I'd like her to test.
I'm simply recounting what Ms. Goddard said as far as clarifying the situation.
Great. Good. May I re-ask the question?
Did you reword?
Yes. I will. Ms. Goddard, a second ago, you said he, meaning her attorney, presented her evidence. When I asked you that question, you said that I'm trying to understand what evidence he presented at the trial in her defense, because prior to that, you stated, the court states that he did not present any evidence. So I want to know if you know of any evidence that was presented at the trial in her defense. That's all I'm asking.
Okay, and I don't 100% know that. That's my assumption that he was representing her on her behalf, assuming that he did have some sort of evidence presented in the case. So if I could be mistaken on that, but my intention on that was he was representing her in lieu of her being there presently.
And
on her behalf.
we read the transcript where it said that no evidence was presented on her behalf. We read that with you there. Just a minute.
I did read that, yes. Again, not being there, I don't know exactly what was presented. I don't have the evidence that the attorney presented or did not present.
If you could go to NRAD 158.
Okay.
Has anybody suggested that that is not Mr. Michaelis's signature under where it says grantee?
It's definitely concerning. I am not a signature expert, nor is we are able to do so. But handwritten documents definitely are concerned, and it was brought up in the complainant's complaint.
So so who wrote fraud on there? Did you write that on there?
I did not.
Do you know who did?
I do not.
Do you know if that would be recorded if it had fraud written on it?
It appears to me that, but I can't tell that that's in pencil, but in the complaint, that 100% there was indicated by the granddaughter that was blank when Peter McKellis Senior signed it, and then the 100% was added after his signature.
Okay, so if you can go back a page, this was recorded on May 1st of 2015.
Correct.
Okay, you know if the granddaughter was around on May 1st of 2015?
No idea.
If you go to the next page, which is 159, that's a notary stamp, correct?
That's correct.
Okay. Do you have any evidence whatsoever to suggest, based upon that notary stamp, that that's not Mr. Michaelis's signature on the page before on 158 as both the seller signature, the buyer signature, and as the grantor grantee signature?
I have to assume it is.
If you could go to page 74. Oh, I'm wrong. Hold on. Right page. Sorry, page 172 or 72.
172?
No, 72.
Okay.
If you look in that page, that's an email from Chris Swanbaum, correct?
Written by Yvette Swanbaum, yes.
Okay. And who is Yvette Swanbaum?
As I understand her, she's the granddaughter of Mr. McKellis Senior.
Okay. Now there's a lot of allegations in this, and one of them is that there's $174,000 that was taken, something like that, correct?
Yes,
Okay. Did you ever investigate that?
I did not, because I did not base that portion on my investigation. That's more civil, and that's not regarding Miss Jett as a licensee.
Okay. So the fact that they're saying that she stole $174,000 from her dad, that's not part of this investigation.
No,
And you have no basis.
I have no evidence to support that.
Okay, thank you. You can go to page 271.
Okay.
Finding today. And what is this document?
Go back and see. This is part of the order of affirmance, excuse me.
Okay, if you can look on page 271. If you can look at the third line down halfway through, it says Jett was not present at the trial, but instead appeared through her trial counsel. See that?
I do.
Okay. Did it appear odd to you that she didn't show up for a trial?
Yeah, we addressed that earlier. It was odd, yes.
Okay. Did you not feel it odd enough to just contact Ms. Jett, say, why were you at trial? Why did you defend yourself?
Jack, only because of repetition. I guess it ties into all of this.
Abstain.
Help them. When you receive, sorry, page 298.
Okay,
And this is the explanation from Ms. Jett, correct?
correct.
Um, that in the last claim, right before the signature line, it says, I will refer to my dad's other children and grandchildren. He always planned for my inheritance to be covered by our property, which was joint tenancy with the right of survivorship, would pass to me without going through probate. The property would not be a part of my dad's estate at the time of death. Have you ever seen that practice in order to avoid probate, where people put property in the children's names in order to avoid probate?
Yes, my previous profession. I mean, it happens, yes.
What was your previous profession?
Financial planning.
Okay. Is that a legitimate financial planning move?
I'm going to object to the question at this point because of relevance. It's going to be
Sustained.
Sustained?
I was actually going to just say we were going totally off track.
This is the very
Question,
essence.
it's repeating and just,
I apologize. You go for it.
go ahead.
He asked questions about this document. The very essence of this is the purpose of this transfer. This is her defense, and I'm asking their witness if she reviewed that and if that is a legitimate action for transferring the property. That's all.
And then you continued on. What was your previous profession?
That's because she said,
But you're going into that. That's what I'm objecting.
because she said, based upon my previous,
That's not relevant to this case. And
well, it is if her prior profession was as a garbage truck driver. Now that she has established what it is, it does make sense. So I appreciate it. That's the only reason for that asking is to make the round.
Thank you.
Did you ask for, when you read through Ms. Jett's declaration, did you ever, you never called her up, but did you ever email her and say, please provide me all of the documents to support every one of your claims?
That's part of the opening letter.
Did
That's
you,
part of the opening letter that says, please provide everything that you have. It's an open statement. Just provide anything that you feel to support your defense about based on the allegations. I'm not going to request specific documents because I don't know what she has. So she could have given anything and everything.
but you, from your investigation, you knew that she did not have any prior events. So this would be her first foray into this world. Correct?
Yes.
Okay. So she gives you a response. Is there any follow-up from you about this, other than the initial letter that says, give us everything? Do you have any other follow-up that says, here's your response, I'm looking for more because I'm the investigator?
I don't know. It would be in this if I followed up with her. I don't recall specifically. I really didn't have too many questions because to me, it's pretty cut and dry. I mean, from what I had, if I ever have any follow-up questions, as I did for the complainant, several, I would follow up with them. But if I didn't follow up, it would be that I'm looking to see that I did or didn't. I don't believe I needed to.
So
Need any further clarification?
So based on what you just said, followed up with the complainant and asked for more documentation, but didn't follow up with the respondent to ask for more documentation.
Based on what I feel is missing. And I did have further questions from the complainant.
All right, I have nothing further.
Can you check I read 271 for me, please?
71?
Yeah.
Those in here were doing the re-exam.
Sorry. Thank you. Bill Super record,
Thank you.
redirects,
Redirect.
Ms. Goddard.
Thank you.
Mr. Goddard. NRED 271. Could you read that new paragraph starting from instead all the way through to that line following the bench trial? So about 7 lines in.
May I just object? This is beyond the scope of my cross-examination.
I would request the commission grant me some latitude. I don't believe it is beyond the scope of his cross-examination in that it speaks to what evidence was provided in the bench trial.
I never asked him if it's fair.
You never asked.
Oh, you limited my question. Yeah, no, you limited my question. And
I
he's
did
going,
not limit you asked many questions and you asked the same one.
Let me
4 or
rephrase.
5 times, so.
you limited my question on this document. And I didn't even ask about this paragraph. That was my, you're right. I didn't limit me on it.
You noted this was asked.
I have it noted that Mr. Van had somehow determined that this order, the judge said that there was no evidence provided, and I am trying to establish that there was indeed evidence provided. So that is the basis for this line of questioning, and it's within these 7 lines. So I ask my commission's indulgence, ask regarding this.
It's okay. It's the same.
That was not in this document. It was on a different document.
I did read this.
This is the court's order. This is.
You did read.
I did read this after his request.
Go right ahead.
I apologize. The Court of Appeals order. Affirming the issue. There was something that I had, the document I had addressed that in my case in chief. And I think actually the record will reflect that Mr. Van had Investigator Goddard actually referred to this particular page in the course of his direct examining, this cross-examination. But
Yes.
so that being the case, could you start from instead, next 7 lines down until we get to that following the measure?
Instead, the case eventually proceeded to a bench trial. At the bench trial, Peter and Swanbaum both testified, and McKellar's amended complaint was introduced into evidence. Jet was not present at the trial, but instead appeared through her trial counsel, Anthony F. Martino, who did not object to the admission of the verified complaint or proffer any witness testimony or evidence on Jet's behalf, aside from the grant, bargain, and sale deed that made Jet a point tenant of the subject property.
So,
Continue. Sorry.
no, that's fine. So just based on this alone, I understand this is different from the district court order. This is the affirmation of the district court order by the Court of Appeals. It appears that prior what you had discussed with Attorney Van regarding no evidence being proffered by DiMartino, that's not true. There was evidence proffered in the underlying district court.
It says witness testimony or evidence on Jet's behalf. Yes.
The verified sale deed. That's what I'm saying. A signed sale. That was
Sale deed is evidence. Yes.
Let's turn to question of the lockout. Could you turn 169, NRED 169. Say it again. NRED 169.
Stand there.
Start from line 6 and read until line 9.
Peter Jr. testified.
You didn't allow me to talk about the lockout. Now he's talking about the lockout.
What?
If we're gonna play, I just hope we play on the same field.
I'm not trying to place it. Please don't insult.
No, I didn't mean it that way. I mean,
Okay.
you told me I couldn't talk about the lockout because we're retrying the case. He's now questioning about retrying the case.
Quick question, quick point of clarification. I objected after he had started talking about the lockout, but I did allow some discussion regarding it. I'm just trying to clarify that portion that was allowed in. However, to the extent that the commission wants to completely disregard the lockout testimony or evidence, then I have no issue with simply not dealing with the lockout issue at all.
To remove it completely on any just one, yes. Yeah. Yes.
Okay, so you're gonna sustain on that condition that we're in line. Correct. Thank you.
Just take one moment. I know you're back on. For those that are here for continuing ed, uh, three hours are up, so you are free if you'd like. You're welcome to stay, but it is 3 hours.
Can I use that for my continuing ed too?
Yeah.
No, 6.
That's a.
I think they should give you.
Then
I think so.
You'd have to talk to Steve about that.
Yeah.
Thank you for coming.
Should cover a CLE.
Thank you.
All right, feels like it.
Okay, I'm sorry, I just.
Maybe
need
if
to
we
let
take
you
a
know.
couple of minutes, right.
It's up.
Nobody wants to spend 20 seconds on.
Can't leave.
Oh, my 3 hours.
So, to recenter discussion, let's turn to NRED 73. This is regarding, the question why this complaint was, brought about 8 years after, the transaction happened.
Okay.
Let's start with the middle of the email where, it's you sending an email to Yvette on February 26th of 2025. You read that to yourself and then, provide what insights you can from that email.
I'm requesting the original transaction documents from 2015. And asking her, is there a particular reason why this is being brought to the division 3 years after why the complaint was filed 3 years later, and I'm basing it on the 2018 date. And then regarding whether there was any issue or district court case on elder abuse.
So I guess this is in line, supports to your representation earlier in your cross-examination testimony that you did ask questions regarding why the timing of the statement of fact that you filed with the division.
Yes.
There's good reason generally for why you didn't get asked Peter Nicholas Senior any questions in this case, right?
Peter McLeod Senior.
Yeah.
He passed away by the time I got the complaint.
Right. Well after.
Yes.
So everything that you had to rely on in your investigation had to come from somewhere. It had to come from somebody other than Peter Nicholas himself. Yes.
Correct.
Turns out it had to come from the complainant and from other details that arose out of the district court testimony, district court, including representations made by Peter Jr. Towards that litigation.
Yes, and I believe the district court case started with Peter McEllis Senior. There was discovery based on his actual testimony, and then Peter McEllis Jr. took over after his passing. So that's direct testimony from himself prior to his death.
So is it fair to say that district court's order encapsulates, at least in part, Peter Nicholas's Senior's representations as far as his grievances with this transaction?
Object to the form that calls for speculation big time because Mr. Nicholas Senior was deceased.
I am going to just say that I was responding to her statement that Peter Nicholas Senior was the one who filed the complaint in the first place. And so at least some aspects of that underlying district court case reflected his position. At least up to the time that he
You
had
want to
filed.
restate that whole question, please?
Let me restate. No, great.
I didn't want you to faint, to whisper.
Appreciate it. So, Ms. Goddard, but for Peter Nicholas being here himself, the complaint that he filed is representative, at least his representation as of the date he filed that complaint is true of his position, correct?
Yes.
So, let's turn to NRED 311. 3-1. 3-1.
3-1.
Okay.
You read through that email, that and the page following.
This is from myself to Ms. Jett. And I'm currently investigating your case and have a few questions below. Can you tell me, have you paid the $30,000 settlement to the recipient? If not, what is your intention for fulfilling that court order? If so, please provide proof of payment.
And this is in addition to the affidavit that she had filed herself in 2024, correct?
Yes,
So
so
it turns out that there was follow-up
Yes.
questions that you had made to.
I obviously forgot. Exactly. I
That's
couldn't
why I
find
asked.
this in the original documents.
I think with that, I and pass it.
Very done. Thank you. Respondent. Cross-examine.
Very quickly.
Yes. Bro.
How, Scott, you've historically looked at complaints and civil actions.
As part of this position, yes.
And the allegations are only that, they're allegations, correct?
Right, until they're proven or given an order by the court, yes.
And so in this case, unfortunately, we don't have the ability to ever know what Mr. Nicholas Sr.'s intentions, desires, thoughts were because he passed away. I think it was 3 months after.
But as I understand, he's the one that initially filed the complaint. He's the one that initially filed the complaint, and there was full testimony from him prior to his death. So yes, I 100% know his intentions because he stated that he's the one that filed the complaint, not Peter Mickelson Jr.
Okay, when you say there was full testimony of him prior to filing the complaint, what do you mean by that? I have no prior testimony.
I'd have to, if someone can refer me back to the district court documents, it was discovery from him and it wasn't direct testimony, but it was just the complaint itself.
That's what I'm getting at. The complaint itself is an allegation.
Yes.
Okay. We don't have any discovery that was conducted prior to his death, correct?
I don't know.
Okay. Do you know if there's any verified answers to discovery signed by Mr. Nicholas Sr. prior to his passing?
Objection, Ms. Stacy Evans, he wouldn't provide.
That's part of the district court.
He wouldn't pay. Objection, Mr. Nicholas would not be providing an answer to his own complaints.
Sustain.
It's not, no, that's not what the question was. Do you know if there were any verified responses to discovery as discovery in that case that Mr. Nicholas signed?
Objection, as far as this exceeds the scope of the questioning, objection that exceeds the scope.
Okay. Can I say something before you sustain it?
Go for it.
Okay. She said that there was testimony and from him prior to filing the complaint. That's what I'm trying to find out.
Can I
What
correct
was
that?
that? Because I don't have any.
My apologies. That I incorrected testimony. I meant the complaint. The original complaint filed to the courts was written by Peter McEllis Sr. I apologize. Is not actual testimony. Again, I don't have the documents that I'm reading from that you're referencing me to, so I'm kind of trying to go on memory.
Okay.
Which is not probably the best idea.
Do you know if the original complaint was verified by Mr. Nicholas Sr.?
Objection, she's not an attorney. I don't think she would understand what a verified complaint is.
I'll ask that question. Do you know what a verified complaint is?
I'm assuming that it's been verified for accuracy, just as, it's been notarized and it's sworn in.
Okay. So, but let me just back up. Is there any other evidence other than the complaint? Set the complaint aside. do you have any other evidence, are you aware of any, that occurred during the discovery period in which Mr. Nicholas Senior participated where he signed anything regarding discovery in this case at all?
I don't 100% understand the question, but the only thing I recall from him himself is the complaint. Filed this report. There could be more, but I'm not aware of it unless you pointed me something.
That's all I'm asking is you're unaware of anything else? I have nothing.
Going to take a moment before we break for lunch. And commissioners, do you have any questions for the witness?
No, I do not.
You are excused and thank you very much. So with that, we're going to take a lunch break.
4 hours? It's only 1 hour.
3 hours and 45 minutes. What, how long?
12:15.
Like 12?
120. I like 120.
120.
120.
And then.
You work closely.
Yes.
No,
saying, she's pushing back on and pushing back at us. So she's like, she sees us as unruly and she's trying to get order.
Maria?
Okay. All right then. Thank
Want to break them out?
Welcome back. He left off, it is now the respondents, what council will each call witnesses and then introduce them.
We check with Maria first
Oh,
to make sure.
Oh,
And I have complete my case in chief.
oh, I'm sorry.
Just confirm that the virtual attendees are
Oh,
prepared.
Requested.
So did I.
That's what I'm gonna call it.
Okay, hi, this is Maria. I'm ready.
Okay,
Thank you.
and in Carson City, are we back on?
We are on in Carson City, and just for everybody's knowledge, there is no public here.
Okay, thank you, Tim.
Yes, ma'am.
Okay, thank you. So we're good to go now.
Okay, so we're good to go now. So Phil,
Thank you very much. For the record, Bill Super, Division One, final housekeeping matter I have before I conclude my case in chief. Under NAC 645.855, attendance of certain brokers required at a disciplinary hearing. I wanted to note for the record that I've spoken with one of respondent Jet's prior brokers, Jaime Velez, who is right there. He was with Keller Williams. He was with Keller Williams Marketplace. He's presently retired, but he's present as well as broker Scott.
yeah.
And, yeah, so Mr. Scott, as I understand it, is respondent Jet's current broker, and then the final broker would be broker Hamrick, who was her broker at the actual time of these. Yeah, and I guess if we could canvass the room and online. Oh, sorry.
Jeff.
Oh, Jeff Moore is here on his screen. Yeah, if you could, Mr. Moore? Okay, thank you. So you're appearing on behalf of, apologies, I forget what this. On behalf of Mr. Hamrick,
No, the real executive.
Realty executive, thank you. Okay, very good. And so, with that, I believe that all the brokers that were required to be here per regulation have made their appearances. I don't have any questions for them, but commissioners, if you do, I believe you could call them to ask. My understanding, based on testimony Ms. Goddard gave, and based on my discussions with Mr. Velez, they had nothing to add as far as substantive testimony on this.
Does any commissioners have any questions for anyone?
No.
No. No, we don't.
Thank you. And with that, the division rests case in chief.
Please. Done.
Yes.
You're gonna call one of them. Okay.
Actually, two of them.
Okay, so you're gonna call.
Oh, no, they're calling brokers.
Now it's the respondents council, and you'll call your witnesses and
Sorry.
evidence.
I'd like to call Mr. Moore.
Okay, I'm gonna ask a favor for myself. I have literally been told that they can't hear me, so they definitely can't. hear me.
I'd like to call Mr. Moore.
No, it's for all of us. They, people in the back can't hear.
Yeah, no,
You're welcome. See, somebody said.
reminds me of the old Garrett
No, he wants you.
Saturday Night Live.
He's calling you.
Remember that?
I remember.
Right here.
With the books?
Yes, sir.
I'm gonna swear.
Yep.
Yes.
Are you ready?
Legally, it's Charles James.
Charles.
On the license, yeah.
Thank you. Okay, if you'd raise your hand, please. Do you solemnly swear or affirm that the testimony you will give in this matter shall be the truth, whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Moore, will you state your name for the record again? Sorry.
Charles J. Moore, or Jeff Moore.
Mr. Moore, have you historically been a broker in Nevada?
30 years.
Okay. Have you left Nevada in the last 30 years? Were you the broker for Miss Jet at the time of this transaction?
I think so.
Okay. Do you remember anybody complaining about this transaction at all during that period of time? How did you find Miss Jet as an agent for you during the time that she was employed with you or with you?
Sometimes a pain in the ass, sometimes a good agent.
Fair?
So we are.
That's what Miss Ruthie thinks about me, but that's okay. And there was testimony earlier that nobody could find you, that they were looking for you in order to investigate. Were you ever contacted?
No.
But you received a letter to show up today.
I did receive a letter, Joe.
Okay, but prior to that, no one has ever contacted you about this transaction.
2 months ago, the division sent me another letter than the last commission. Got postponed.
Okay, prior to that, has anybody contacted you about this file, about this transaction, about anything associated with it?
Not that I,
And you've been in town during that whole period of time? Generally?
generally speaking, yeah.
Okay.
Nothing further. Really quick, thank you for your appearance here today. Who's Robert Hamrick?
He'd be the broker, Coldwell Banker.
Okay, but he's not associated with your brokerage. So Investigator Goddard, if she, you wouldn't know anything about communications between him and her, in the course of her investigation, right?
Who?
Robert Hamrick.
No.
No further questions. Thank you.
Where you go?
Great, Jeff.
Amen. Thank you.
Does the commission have any questions?
Oh, wait.
Just one moment.
Sorry. I guess I can't release it.
Oh,
Questions?
I do.
I do too. Go ahead, do the first.
So, one of the reasons maybe she said she didn't get you, you sold your brokerage, right? So
That's
you-
correct.
You weren't, if she looked up Realty Execs, she would not find you. You were ERA.
Right.
Okay, that's it.
I
Thanks,
sold Realty Executives to
ERA. Thank you.
I've got just one question, and we know each other. And if something going back to 2015, you had managers, I'm sure, that would actually, if something was getting delivered or a complaint or something about an agent, wouldn't it go down to the chain of command before it ever reached you or Fafi? You had managers and other people, as far as I remember.
Typically, they'd come straight to us.
Really? Okay. That was my question. Thank you.
Okay.
Thank
you. Okay, next witness, we're gonna call is Karina Jett.
Say his name.
Oh, yeah. For the record, Joshua Floth, attorney, for Karina Jett.
Thank you. I have to swear in.
Oh, yeah, my bad.
You couldn't take my job. Please raise your right hand. Do you solemnly swear and or affirm to tell us that you give testimony you shall and will swear shall be the truth, whole truth, and nothing but the truth? Thank you.
Okay. So, can you please identify yourself for the record?
My name is Karina Jett.
And, what is your occupation? And how long have you been a realtor?
14 years.
Okay. And other than this case, have you ever been subject to any discipline by NRED? Did you ever have any real estate ventures with one of your family members?
Yes.
And what was the nature of that deal?
I had several real estate transactions with my mother and my aunt.
And the underlying transaction that was subject to this matter. Can you explain Can you explain the nature of that deal?
The one that we're talking about?
Yes, correct.
Ms. Jack, can you speak up, please?
Oh, yeah, I think you have to speak a little louder.
Okay, I'm sorry. Okay, so ask me a more direct question.
Yeah. What was the arrangement between you and your father? regarding Luster View.
So my father was older in age and he was in between households, I will say. So he was living with me and his girlfriend at the time, and he was going back and forth. And he decided that he would prefer to live alone. And we decided to purchase a home, and he used his VA. A little backstory.
Let me just stop right there, just for one quick second. I just asked council if he had any objections to any of the documents that we admitted. He said no. So I would just let everybody know that they're being admitted generally without objection.
Yeah, let's move to admit the documents.
Times down.
A little backstory.
Just for clarification, are you requesting to admit all of your documents? Can you just list it out as an exhibit?
Oh,
7.
Exhibit A through JJ.
Perfect, thank you.
The reason why my father was in back and forth between homes is because my father had recently divorced my mother, and why this is relevant to the story is because my father had cheated on my mother with her best friend. So my father was going back and forth between my mother's best friend and my home, back and forth. And he decided to finally end the relationship with girlfriend, and he wanted to purchase the home.
Okay, and how did you guys come? How did he find Luster View?
We had been searching for months. We saw about 20 homes, and the home was about approximately less than a mile from my house. So that's why we chose that property.
Okay, and I'd like you to turn to what's marked as Exhibit A in our binder. I think you may have.
Do I have the wrong binder?
Those are binders that we created. It's the same documents for, it's our documents, yeah. We created some for our doc. Okay, so, and can you review this document, kind of, after you finish reviewing it, what, do you recognize this document?
Yes,
Okay, and what is it?
it's the dues sold and the residential purchase agreement. for the home.
Okay, and what's the date of this purchase agreement?
March 2nd, 2015.
And who does it identify, and what does the purchasing agreement identify the buyer as?
Peter Michaels,
And just to confirm, who was that?
my father.
Okay. And did your dad consult with you regarding this purchase?
Yes,
Okay. And you spoke about it earlier, but so is it fair to say that the original purpose was to purchase the property for Peter to live in?
yes.
Okay. And was there any discussions of renting out any of the property?
Yeah, he wanted to rent out part of the property to help pay for the expenses,
And by expenses, what do you mean?
like the mortgage, the utility bill, the pool, just the day-to-day home expenses of the property.
And for this transaction, did you act as the real estate agent?
I did.
Okay. And if you could go to Bates stamp, which is the number at the bottom, the KJNRED 00, and then go to 19.
Yes.
And before discussing this, did Luster View fit the needs that Peter was looking for?
Yes, it had a downstairs master because he was not able to go upstairs. So that home fit with him. It actually had 2 masters, so he was going to live in the downstairs master.
Who was the title company for this transaction?
Well, I originally requested Tycor title, but the property was bank owned. So the bank directed Palomar.
Excuse me.
And if you could go to Exhibit K. Be easier for you to.
Yes.
Can you review this document? Let me know what it is.
It's the borrower statement.
And okay. And what did this document effectively do?
It just showed where the money went and how much money he put down and the cost of the loan and any fees associated with the property.
Okay. And do you recall going over this with your father?
Yes.
And what was your impressions of your dad's feelings about purchasing the property following the closing?
He was happy to be not in limbo between residences.
And did dad, did Peter Senior, did he intend on moving in right away?
Yes. Well, until I furnished it. He wanted me to furnish the property because he had no furniture. So he was waiting for me to furnish.
And did you furnish the property?
Yes, I did.
Okay. And then after you furnished the property, did he move into the property?
No, he did not.
And why did he not?
Because he decided to reconcile with his girlfriend and he wanted to move back in.
Okay. And what was the name of the girlfriend?
Her name was Hoy Hastings.
Okay. And where did she live?
She lived on I don't know exact address, but she lived on Clear Blue Drive.
And after he moved in with Miss Hastings, did he remain there?
Yes, he remained there until he passed.
Okay. And did he ever move anything, any of his personal belongings into Lusterview?
Yes, he did.
And how did he get those items in to Lusterview?
In about June or July of 2015, I met him at his storage unit on Cheyenne. And me and my cousin moved. I had a truck at the time and we moved all of his belongings into the garage.
And did your dad ever have a key for the property?
Yes.
And did you ever change the locks for the property? What was your address in 2015?
889. I'm sorry, 10198 Dedek Avenue.
Okay. And you mentioned earlier in your testimony that your dad would split time between your house and Miss Hastings. So how would you say that split was? Like, how long would he stay with Miss Hastings? How long would he stay with you?
Sometimes he'd be gone a week, sometimes he'd be gone 2 or 3 days. It just depends on if they were fighting or not fighting.
And did you guys have to use a mortgage to acquire the Lusterview?
Yes.
And whose name was that mortgage in?
For his.
Right. And did Peter Senior ever did he have to put a down payment down?
Yes.
And how much was that down payment?
I believe the total was about 15,000.
Okay. And was there did he make any payments towards the mortgage?
Yes, he made the first payment.
Okay. And did he make the second payment?
No.
Who made the second payment? And who made the subsequent mortgage payments for Lusterview?
I did until this year.
Oh. And Why were you making these payments?
Because my father wanted me to rent the property out. And at his direction, I rented it out and took care of and managed the property.
And we had a previous testimony, Ms. Goddard, regarding the VA loan and the requirement to have a primary residency. Did you have any discussions with your father regarding that provision of a VA loan?
Yes, I discussed it with him numerous times because what I wanted more was him to live in that home because I didn't want him to go back to the girlfriend that he cheated on my mother. So there's nothing more that I wanted than my father to live in that house.
And how close was that house to your house again?
Less than a mile.
And what was the benefit of having those close proximity?
So I could check on him and take care of him and buy groceries for him and just be around him in his old age.
And how is the ownership of the house listed on the deed? The original deed.
The original deed, probably just single man.
Okay. And was there any subsequent deeds created?
Yes.
And what was that deed?
It was a deed adding me to the deed as a right of survivorship. My father was in his 80s.
Okay. And you kind of mentioned, but what was the purpose of creating that deed and putting you on?
That was, I was going to take care of my father. I was going to help him out in his advanced age, and then he would leave that to me as my inheritance.
Okay. And so let's move on to Exhibit AA. And do you recognize this document?
Yes.
And what is this?
It's the deed.
Okay. And when was this deed executed?
The date of the closing.
What date was that?
April 17th, 2015.
Okay. And were you there when he filled out this deed?
Yes.
And where was this deed filled out?
At Shalimar Escrow.
Okay. And if you could go to KJN RED 0132. And what is this page?
It's a declaration of value page.
Okay. And where it says seller signature, what signature is that? Okay. And was this document created at the same time? I mean, was it signed at the same time as the previous page?
Yes.
Okay. And if you could go to the next page, what is this stating?
When my father went to go record the deed was not in compliance. And so the county recorder's office rejected the deed.
Okay. And after it was rejected, what actions did you guys take?
We had to correct the forms. We had to correct the forms properly. And I also had to provide documentation on how he was my father.
And what kind of documentation was that?
Well, I had to provide, I was not born in this country, so I had to provide translated documents from my home country to here to show that he was my father on the original birth.
And if you could go to BB. And what is this document?
It is a deed.
And is this document different from the document in AA?
Yes.
And how is it? What's the difference between that?
That this shows that I have been added to the deed as a joint tenant.
And was this deed recorded? And on what date was this deed recorded?
May 1st.
So was this deed the corrected deed that you discussed? And if you could go to the next page, which is 138, and where it says 4B, explain the reason for exemption. What does that state?
Transfer between father to add daughter.
Hey. And whose handwriting?
My father's.
And when was this document executed? Or around what time?
April 17th.
Okay. And was this document executed in response to the deed being rejected?
Yes.
Okay. And do you recall where this document was executed?
It was at Shalimar Escrow by the notary.
And when did you start renting out Lusterview?
Approximately maybe June or July of 2000.
Okay. And
I'm sorry, could you speak? Yes, I will. Sorry.
And who was managing the rentals?
I was managing.
Did Peter Senior do anything with regards to managing the property?
No.
And after your addition to the deed, did that change your actions in any way with how you approach the property?
No, because I was on the deed, so I was the owner, part owner of the property. So I was acting as if I was the owner, so I was renting it out as the owner.
Okay. And again, where was Peter living during this time?
At Clearwood.
Okay, if you could go to Exhibit CC. And if you could review this, after you reviewed it, do you recall this document?
Yes.
And what is this document saying?
That he changed his address to 8825 Clear Blue Drive on June 9th of 2015.
And do you recall the reason why he changed it?
Yes, because he permanently moved back into his girlfriend's home.
And how did you come to acquire this document?
Gave it to me.
And would that be a common occurrence of him giving you mail?
Yes. The reason why he forwarded the mail is because he wanted to make sure that his mail was going to him and I would be giving it to him. And if there was a problem with the mailing service at my home, that I could show this to the postman.
Okay. And what was your thoughts on Peter Senior moving into Clear Blue?
I was devastated.
And
I didn't want my father to move back in with the woman that he cheated on my mother.
And this, did you have discussions with him regarding his choice to move back in with Miss Hastings?
Yeah, that was a contention in our relationship.
And when did he inform you that he wasn't going to be moving into Lusterview?
After he made the first mortgage payments, pretty much after that.
And was that, and you testified earlier regarding your, I guess, your furnishing of the house. Was that, was the first mortgage payment due before you furnished the house or after?
After.
And So the allegations made in both the civil suit and the complaint stated that you had locked out your father from the property following the house being transferred into your name. Would you agree with these allegations? And following the closing of the property, what transpired between you and your father in regards to Lusterview?
After the closing?
Yeah, immediately after.
I mean, the house was empty, so I mean, there was nothing really transpired. I was just basically getting things ready to furnish the property.
And what happened following your addition to the title?
I was still buying furniture for my dad, as I thought, and furnishing the property for him to live.
And how would you describe your relationship with your father in the year following the closing on Lusterview?
Fine.
Okay. And did your dad ever trust you to manage his affairs in the year following?
Yes.
Okay, and can we please go to Exhibit GG? And can you just look over this document once you do? Do you recognize it?
Yes.
And what is this?
It's a Department of Veteran Affairs, Healthcare Proxy and Living Will, Cerebral Power.
Okay, and what was the effect of this document?
My father was at the time in the hospital, and he called me to sign these documents because he was not, I mean, he was in his 80s, so he wanted me to have some type of say in if something were to happen to him.
Okay, and what was the date that Peter signed? If you go to date stamp 147. And at the top, there's a signature. Whose signature is that?
My father's.
And what's the date of that?
March 25th, 2016.
And in relation to the closing on the house, how far after was that from the closing?
Almost 1 year.
And did you keep in regular contact with him throughout this time?
Yes.
And did your dad have conversations with you about adding you to as his healthcare power of attorney?
I didn't know he was going to do this until I showed up at the VA hospital.
And did he tell you to come to the VA hospital? And when you got there, he had this document waiting for you to sign, waiting for you. And at the time of your dad's passing, did you owe him any money?
I owed him a little money from money that I was going to pay him back towards the down payment of this. We were partners in this.
And how much was that down payment again?
$15,000.
And how much money did you pay him back?
I paid him. I owed him $7,000 left.
Yeah. And if we could go to Exhibit GG, and it's going to be Bates stamp. Oh, well, first off, do you recognize this document?
Yes.
What is it?
My father's will.
Okay. And if we could go to page 2 of this document, but 157 is the Bates stamp.
Yep.
And if you could look at section 4, what does that state?
To my daughter, Karina Michaelis, that is my maiden name. I give the following not because any will or animosity towards her, but because I have amply provided for her in the past. I hereby forgive the indebtedness that remains on the note of the original amount of $29,000 that Karina Michaelis owes me, which was loaned to her to assist her in her home located at 2340 Legacy Island Circle, Henderson, Nevada, in which she currently shares ownership with my wife.
Okay. And what is the date of this will? You go to 160.
160?
Mm-hmm. Yeah. Middle of the page.
March of 2010.
And following the execution of this will, did you ever repay him?
Yes, I did.
And if we could flip to Exhibit H.
Hold on. I need to pause.
Oh yeah. Don't bet.
Yes, I did.
And let me know when you're there. Oh, are you good to go?
Just needs a minute.
Oh,
Her recorder.
my bad.
I'll let him stay. It's just a minute, guys. And
Oh yeah.
Flash.
Okay, reason. Okay, awesome. Okay, so are you on Exhibit H?
H or HH?
H, 1H.
Correct. Yes, I am.
And you recognize this document?
Yes.
And what is this?
It's a cashier's check that I left my father on the loan that I had on my home on Legacy Island Circle. And it's a receipt from him saying that this was the final payment of what I owed him. And it says, to whom it may concern, this check is the final payment for the previous loan and this is the final payment. Karina no longer owes me any money, Peter Michaelis, and it's a copy of the cashier's check that I gave him.
Okay. And following this, did Peter consider the debt paid? And is this debt the same debt that was mentioned in the will?
Correct.
And so going off of this, after you took control after you were deeded over the property,
Sorry,
oh no, you're good.
that was lunch.
So after you were deeded onto the property, how would you go about finding renters?
I would either list them on the MLS or Airbnb.
Okay. And were these long-term rentals?
No, they were more short-term because they were, because it was a furnished home. I would try to find whatever I could, because furnished rentals are not as easy to rent.
Okay. And did Peter ever ask for access to the property?
Yes.
And did you allow him access? And did you manage the insurance for the property?
No, I did not.
Was there insurance for the property?
Yes.
And do you recall who that insurance was with?
I think it was with Farmers and
Okay. If we could go to Exhibit B. And do you recall this document?
Yes.
And who was this document addressed to?
My father,
And what is the address listed there?
8825 Clearview Drive,
And what's the date of this document?
11/22/2016.
And what is this document stating and discussing?
The home insurance policy.
And who was this with?
Farmers Insurance.
Uh, and was there ever a need to get different insurance on the property?
Yes, he wanted to get a landlord's protection rider on in case any damage because it was a firm property.
Okay, and we can go to Exhibit C. And what is this?
It is the landlord's protection declaration page.
Okay. And was this the policy you were just discussing?
Yeah.
And what's the effective date of this?
11/22/2017.
And under property insured, what is the property that's discussing?
889 Lesterville Court.
Okay, and who does it identify as the named insured?
Peter Michaelis,
And what address does it list as?
8825 Clear Blue Drive.
And how did you get these documents from the insurance?
My father gave them to me
And why did he give you these documents?
because he didn't tell his girlfriend that he bought the house. So he hid it from his girlfriend and my siblings. So I had all the documents.
Was there ever a need, who managed the mortgages of the mortgage payments of the property?
Well, my father, the payments were originally going to him. But after the first year, the payment changed. And so he was upset with me because the payment changed, but I told him like, I don't get the mortgage statement. So I didn't know that payments changed because the taxes had changed and the insurance premium changed. So at that point, he decided to go to Wells Fargo and add me.
Okay. And with that, can we go to Exhibit R? And what is this document?
It's an authorization to release information document from Wells Fargo.
And is this the authorization you were just discussing?
Yes.
And who does it name as the third party?
Name's me.
And what was the effect of this document?
The effect of this document?
Yeah, what did this document do?
So it allowed me to ask questions about the mortgage. It allowed me to set up or change anything. It allowed me to update any information and get access to the amount because when I was making the payments the previous year, I had a set amount. When the payments changed, I didn't have access and that upset my father. So he added me to the mortgage statement so I could get the statement so I could pay the correct amount.
And if you look at the bottom, where it says borrower, whose signature is that?
My father's.
And what's the date of that signature?
August 25th, 2016.
Okay. And do you know your father's social security number?
Not anymore.
Oh, okay. We can skip that. So let's go to Exhibit M. And let me know when you're there.
Here.
Oh, do you recognize this document?
Yeah.
And what is this?
So this is a document after my father. After you call Wells Fargo, you can't just add somebody to an account. They have to send you an authorization form, which you just saw. He was sent the authorization form to his address at Clear Blue. And then he sent in authorization. And then this is the bank confirming the authorization to the account.
Okay. And what was the date of this this letter?
August 29th, 2016.
And just to confirm, what was the date that the house was purchased? Or that the closing occurred? You can recall.
April 17th, 2015.
And did you use the authorization that Peter granted you to manage the property?
Yes.
And now let's go to Exhibit O. And what is this document?
It's a document requesting so now my father wrote Wells Fargo saying that he requested they provide payment to the payment amount for his account.
Okay. And was that information disclosed?
To me?
Yes.
Yes, this form is sent to my address and to me.
And did you pay? I mean, what expenses were you responsible for paying with the property?
All of everything was in my name except for the mortgage.
And if we could go to Exhibit X. And what is this document?
This is a receipt for the washer machine that I purchased for the house.
And what's the date of this?
June 5th, 2015.
Okay. And was this around the time that you've previously testified to furnishing the house?
Correct.
And if we could go to Exhibit Y. And what is this document?
It is an intent to lien document.
And who is it being sent by?
Republic Services.
Okay. And if you can look at the bottom, it's addressed to individuals. Who's it addressed to?
Peter Michaelis and Karina Jett.
And what address was this sent to?
8825 Clear Blue Drive.
Did you ever live at Clear Blue?
No.
And what was the property that this notice of delinquency is for?
889 Luster View Court.
And how are the utilities paid for Lusterview?
I was paying for the utilities.
And where was that money coming from?
My bank.
And what about where was the money being used to pay for the mortgage coming?
My bank.
And why were you managing the expenses and not Peter?
Because he was going to leave the house to me, so he didn't want to live there anymore. So he basically said, take care of the house. And I said I would rent it out and take care of the expenses.
And did you ever have any disagreements with your father over Lusterview in particular?
Not until 2017.
And what happened in 2017?
My half siblings found out that my father purchased this house.
And sorry, can you identify your half siblings for the record?
So my sister, Michelle Carpentier, and my half brother, Peter Michaelis Jr., found out at a wedding of my father's grandson that my father had told them that he had purchased this home for me.
And what was their reaction to that?
They were angry.
And did you have any discussions with them following that?
Not really. I did not really have a relationship with my half siblings. We grew up my father those children were his first wives. I was the child of the fourth wife. So we had such an age difference. We grew up in totally different households. We did not grow up together. My father, my sister, and my mother were the same age. So we had a very big age spread.
And what happened following their discovery of the house being in your name as well?
Well, my father and I had a very tumultuous relationship after the girlfriend issue, because it was very hard for me my father didn't understand the fact that I could not be friendly and bring his girlfriend over to my house. He cheated on my mother, her best friend. So he didn't understand that. So he couldn't, it was very upsetting to him that I wouldn't just be like Switzerland and basically welcome her with open arms. And I couldn't turn the dagger in my mother's heart and let this woman be a part of our lives. And that was a big tension with me.
And did anything arise out of the disagreement over the ownership of Lusterview?
So with that and him telling the siblings about that, they all turned against me during this time.
Okay. And were there any legal actions taken?
Yes.
And what was that?
He sued me for fraud.
Okay. And did you hire an attorney?
I did.
What was his name?
Well, the attorney I thought I was hiring was Robert Walsh. What happened was at the trial, he sent in another attorney that didn't know my case. And he told me not to appear in court. What I didn't realize at the time is that the reason why he told me not to appear in court is because I didn't know that he never submitted any of the evidence that I had given.
And did you have multiple meetings with your attorney to go over the evidence?
So originally Robert Walsh had sent Matthew Palawowski. He was an attorney at the time of record multiple times. And then prior to the final action, Matthew Palawowski left the firm and he put this other attorney in that I didn't know, and we didn't have any meetings.
But you turned over all your documents to your attorney,
I
correct?
did turn them all into.
And as far as you're aware, what did the attorney do with the documents that you turned over to them?
He obviously did nothing because I didn't know that he didn't turn in the documents until after the court case was resolved.
And it would be a fair statement to say that the documents that you presented in your defense are documents that you presented to your attorney at that time?
Correct.
And were you relying on your counsel in defending yourself in the civil action?
Yes. I mean, I have never been ever in my life in a court case. And this was the first time I was being sued. I was being sued by my father, which was heartbreaking for me. And I was very naive in representation. I didn't know that my attorney wasn't doing what he was supposed to be doing. I thought I hired somebody to help me, and in turn, he hurt me and he didn't do his job.
And did your attorney ever explain why he didn't disclose the documents?
No, I don't have it. We never, no. That's why I feel like he told me not to go up to court, because then I would realize that he didn't turn in the documents.
And what was the ultimate outcome of that case?
I lost that case.
And do you plan on pursuing a malpractice claim against your former attorney?
Absolutely.
And did you attempt to appeal the decision?
Yes, I did.
And what was the outcome of that?
Lost the appeal.
And do you recall the reasons for why you lost?
I don't really understand the whole legal terminology for it, but what was very upsetting to me is that when I did appeal, I wasn't allowed to say like, well, my attorney didn't provide the evidence. My attorney didn't give, like, in the appeal, I wasn't allowed to say my attorney mishandled anything. I was only allowed to just give my best, like I just tried to get the trial done over again because I didn't have a fair shake in the first place. And my attorney informed me, my second attorney informed me that I wasn't allowed to say that my attorney didn't present the evidence because that would be something that I would have to do at a malpractice, not in the appeal.
And who's Yvette? Yvette Swanbaum.
She is my father's granddaughter and my half sister's daughter.
And was she the one that offered that I guess initiated this action?
Yes.
That we're sitting here.
Yes.
How often would you have contact with Yvette?
Not very often, because what happened was when my father cheated on my mother, it created a divide in the family. So I did not have much contact with them because my mother was my mother, and then that was their grandfather. So they took the side of their grandfather, and I tried to stay as neutral as possible, but I was more on my mother's side because my mother was being harmed. So they never liked my mother. So it was a very big divide within the family.
And how often did you discuss this case with Yvette?
Never. She never knew about the house until 2017, and that's when we discussed it with her. I had discussed it with her, and then when my dad passed, I discussed it.
And was she a part of the underlying case, the underlying civil action?
No.
She wasn't a party?
No.
Was she a witness?
No. Oh, yes, she was a witness in that. Yes, she was a witness.
And you said she was a witness. What did she testify about?
She testified that, well, she did, I don't know because I wasn't there, but I just know from what the court documents say that she had lied about, being, she never was around during any of my relationship with my father because there was that divide.
And so have you ever had any other complaints against you in your capacity as a real estate agent?
No, I have not.
And then if we can go to Exhibit I. And what is this document?
It's a document from the Las Vegas Realtors Association.
And what is this document stating?
Says the letter is confirm that Karina and Jet have been a member in good standing with the Las Vegas Realtors since March of 2012. The National and Nevada Association of Realtors dues are paid for the year 2026.
And until that wedding in 2017, well, how would you describe your relationship with your father?
I mean, good for the, I mean, like I said, I adored my father. My father was a hard man. He was in his 80s. He had gone through a lot. He was born in the 20s. He would be 100 this today. So he grew up during the Depression. So it was a very big age gap between me and him. My father and I were 48 years difference in age. So it was a very hard, he was a hard man. And I did the best I can to get along with him.
And how would you guys just have conversations regularly though?
Absolutely. I contacted my father every day, one point, until the fair started.
And when was that affair again?
Well, I didn't know he was having an affair until I would say 2013. I had
And we can get past. So with regards to the actual transaction for the purchase of Lesterview, you were the real estate agent, correct?
Correct.
Did you take commission?
I took a partial commission. I gave the rest of it to father.
And do you in Exhibit K? And if under commissions, what does it state?
Right, it's not.
Okay. On the first page under commissions, it's like,
Oh, I contributed 3,500.
and in credits, what does that mean?
Closing costs.
So you say it's fair to say that your commission payment went towards the closing costs?
Correct.
And so when you were sued, what was your initial reaction when you were served with the complaint for the civil action?
I was heartbroken that my father would do this to me.
And did you talk to your dad about that after he filed suit?
Not really. I mean, we already were estranged of them.
And did you have any discussions with any one of your family members after the suit was filed?
No.
Okay. And how do you recall how long after the suit was filed that Peter passed away?
I believe the suit was filed in 2017 and he died either the end of 2016 or 17, and then he died October of 2018.
And by your recollection, was there ever any depositions taken of him?
No deposition.
Was there any ever? Hey, by your recollection, do you know if your attorney ever sent any discovery requests to him?
I don't know.
And overall, the purchase of Lusterview, what was your, in the whole transaction, what was your intention regarding all of this, regarding getting Lusterview?
My intention was for my father to live there until he died. I was gonna take care of him, help him with whatever he needed. And those plans unfortunately changed. Not for what I wanted, but you can't control people's heart. So that's what he wanted to do.
Okay, I think that I passed the witness.
Mr. Sue.
Ms. Jett, you said earlier on your testimony that before what the view was even in play, you found the split time between your house and his girlfriend's house?
Yeah.
What was the distribution of that? Like how often we stay at your house, how often at his girlfriend's house?
I think I answered that already. I said that sometimes he would stay 5 days at my house, sometimes 2, 3, depending on their volatility of their relationship. It would not be consistent.
Is your representation that he never stayed, that he moved into her house after the Lester View transaction consummated, like closed, but like he moved to her house. Her house was no longer in play. You no longer lived there after it.
Correct.
How far is her house from Lester View?
I'm not very good with mileage, but the house was located in Silverado Ranch and her home was located in the lakes. So I would say about a 25-minute drive.
And your house is much closer to the Lester View house?
Correct.
Like 5 minutes?
Less than a minute, less than a mile, sorry.
It's about 5 minutes.
Yes.
So, it's your representation that no lockout happened, you never changed the keys, and you always had access to the property if you wanted it?
Absolutely. I took his stuff from storage and put it in the home because he wanted to not have to pay for storage fees anymore. So when we did the rental, I don't have it with me because it's been so long, but when I rented the property, I always had to put owner left storage items in the garage because he left his stuff from his storage unit in Luster. And we moved that in June of 2015. We acquired that. He acquired, I went with him to storage unit, get his stuff.
It's also, recall, was your recollection that you had admonished and warned him numerous times of his obligations under his VA loan to make that his personal residence?
That's
And you understand the fraud impacts that could come into play if he didn't actually use that as primary residence.
right, but I cannot force somebody to move into a home. I wanted nothing more for my father to live there, like I stated, because I did not want him to be living with my mom's former best friend.
It was also your statement under oath that Yvette Seedbaum did not learn of this house transaction until 2017.
Correct.
How about Peter Jr.?
That is around the same time also.
So you understand your testimony directly controverts their representations in district court that shortly after the lockout happened, they reached out to you and asked, why did you lock out that home?
That is correct because they lied.
Okay. So they're saying that they accelerated their knowledge of the house by about 2 years.
Correct.
You also discussed how everything was in your name except the mortgage. Do you recall making that statement? That you covered everything centralized for the house except for the.
That is correct.
Why is that?
because my father wanted me to pay all the bill because I was receiving the rents from the bills. So I was paying I was basically the accountant for the house.
I guess I'm being a bit obtuse. It was a VA loan still. It was under his name alone.
That is correct. I told my father, he was well aware of the 6-month clause. He knew about that, but he did not care. He did not care about anything but his own feelings.
As a real estate professional, did you not believe you had an obligation to either make your client aware that they were violating the law?
I did make him aware many times. There's nothing more than I wanted him to do was to live in that home.
Then why didn't you sell the house? Somehow divest yourself of that property that was obviously in violation of the mortgage.
That wasn't my choice.
You had half an interest in it.
I know, but if he doesn't want to sell it, then it's not just one person's decision.
As far as the expenses that you maintained, how did you manage to let multiple utilities go into delinquency?
I mean, if you see what the bill is, it's for $93. It's not like I left it for a long period of time. Sometime, and that was the trash. So when you originally file, like when you originally close on a house, they send it to the person that owns the house and his address. So his address was on, I never got the bill. My father forgot to give it to me. So if you look at the bill, you can see it's his handwriting. He gave me the bill and said, call, can you tell me what, I refer back to the page, please, where that bill is, so I can show him the explanation.
I believe, exhibit Y. Proper, that's it, yeah.
Okay, let's go back to the bill. So the bill was for $93. So the bill was going to his house at Clear Blue. So I did not receive the bill, and that's why it was delinquent. He was receiving the bills and giving them to me. So I did not receive the bill. If you look at the bottom of that page, it says Jerry Marks. So my father said, here, call Jerry Marks and settle this bill. That is the number to the person that I was supposed to call at Republic Services. There's no way for me to get this bill unless my father gave it to me to pay.
There's a notation at the top of that page Y saying Karina AutoPay. What does that mean?
That I was trying, that was a note to me to change it to AutoPay.
Did you do that after this?
Yes.
Let's turn to exhibit X. This is a delinquent utility note from Wells Fargo Home Mortgage dated August 15 of 2016 for an amount of.
That is not correct.
Sorry. W.
What page?
W, the KJN Red 120.
Yes.
So what happened here? Well, why the delinquency for 800?
Because if you notice on the date, it's August 5th of 2016. It was delivered to my father's address. So he was getting bills, okay? And probably what happened was this was prior to me allowing access to the Wells Fargo. Can we refer back to the Wells Fargo? Him attaching me to the Wells. So the Wells Fargo, he added me. I didn't have access. So he was giving me the bills to pay, but they were given to him, his address. So I didn't have knowledge of the bills until he gave them to me.
But you represent that you were paying them. So how were you paying them then access them?
No, I'm saying they weren't being sent to me. If you see on the bill, it was being sent to his Clear Blue address. He gave this to me in reference. But what happens is this particular case, So he was given the bill in August 5th of 2016. If you notice, I wasn't allowed authorization until August 29th of 2016. That's when he started giving me authorization because I was not aware of these delinquent bills.
Just, where are you getting August 29th?
So if you look at the Exhibit W, you're referencing the bill into August 5th of 2016. If you go back to M, I wasn't added to the account until August 29th of 2016. So I was unaware of these bills that were given to him.
Okay, but you understand, M talks about his mortgage, not all the other utilities.
But this utility, this mortgage, this document is from the mortgage company.
I understand, but it is, the underlying bill is about a utility delinquency, not about mortgage. Access to his mortgage information doesn't mean that, doesn't explain why there was a delinquency of that large amount from that utility.
I don't remember or recall what this bill was for, and it doesn't say. So I couldn't have, I don't know what exactly this bill could have been.
That's fine. All right, thank you. I'm on. Let's look at KJ NRED 62, Exhibit D.
Can you?
KJ, Exhibit D, KJ NRED 2. 60, yeah. So we had previously been pointed in your direct examination to Wells Fargo documents showing that he was receiving documents at the blue sort of blue location. How about this one though, that shows a home insurance reinstatement dated June 19 of 2015. Apparently,
So
affection you at your address.
So I did not, I don't know why this could have gotten like, because he added my name to the reinstatement. He used my address because he wanted the bill to go to my address.
So for this one insurance thing, he would, but he didn't do it for the utilities. He didn't do it for the mortgage, but for this one bill, he decided to put your address.
He did do it in like on some bills, on some bills he didn't do it.
Exhibit E, KJ NRED 7. Same question. Exhibit E. The same question, you have a payment stub, care of you at your FedEx address. Same deal that you were paying for this insurance because you decided in this one instance to send this to your address. And he didn't do it for all the others.
So the bill, the trash bill went to his Clearblue address because when he some bills went to me, some bills went to him.
But didn't you initially testify that you were in charge of all his utilities?
Correct, but
And
that
you
doesn't
paid
mean
the
that I
mortgage
didn't pay
going.
for the bills. I mean, how would,
If you can let me finish my question.
sorry.
Your testimony earlier was that he made an initial mortgage payment and you made the mortgage payments out. Your testimony was that you paid all the utilities. And I guess before a couple of exceptions. So I guess I'm trying to get at is, did you know? Because if you have visibility into those things, then these delinquencies shouldn't have been an issue. Frankly, I see an auto pay, note to yourself to make an auto pay on this Exhibit Y delinquency that was dated for what, February of 2016. And then in August of 2016, you have another delinquency, which also states that you're going to start auto pay there. But 6 months go by and you don't auto pay everything.
Object, the form misstates the testimony, the prior testimony was.
Cannot hear you.
I apologize. Object, it misstates prior testimony. Her testimony was that as they would come and as he would realize they were delinquent, then he would transfer them over one at a time. It wasn't that she's never testified she was responsible. She has testified that she paid them when he provided them to her.
I guess my rebuttal to that would be, I have it down as quote. Everything was in Ms. Jet's name except for the mortgage. That's a direct quote from her testimony and correct.
I think I misstates the testimony. The documents speak for themselves. They weren't all in her name. They were in his name and her name and various.
Some of the bills were in the clear blue address. You can see it on the bill.
I'll move on to this line. Now, as far as, oh, sorry.
That statement. What exactly, to me, what you want me to,
I think he was objecting to my line of questioning.
you know, and the both of you went back and forth at each other.
So we just need a ruling of whether to strike my question because, or to overrule or sustain the budget.
We're gonna. You, sustain, right?
Yes.
Yes.
Right.
Yes.
Sustain me.
Yeah,
That's
sustain
two.
you.
Thank you.
Don't be looking for anything.
Gonna get her.
You press your luck.
Go for the trifecta. The heck.
Do you recall making a testimony regarding where these utilities and mortgage was being paid from, being from your bank account?
Correct.
Did you have a separate bank account for the costs of the Luster View home, or did you commingle the monies with your owners?
Probably a little bit of both. Yeah. I mean, it just depends because sometimes it was rented and the tenant would pay the utility. We would take over the payment, would be changed over.
I'm sorry, you're saying the tenant would pay for utilities?
Sometimes, depending on the length of the rental, sometimes the tenant would pay all of the utilities, or sometimes I would pay the utilities.
We'll get to that in a second, but first, so let's as to my line of questioning right now is so your answer there to my question was that it depends and monies would probably commingle between your personal account and the money that would have been paying for Luster.
Yeah.
So rental income then I imagine would also have been.
I can't remember because it's been a long time, but it is possible that I did have it. I did have an own Luster View account.
How was the property being rented? Do you have a general recollection of?
I stated Airbnb and MLS.
Okay.
And I also would forward the rental statements to my father's accountant on a regular basis, so he had a accounting of what was going on.
You didn't present any evidence of that, of those
Yes, I
accounts?
did.
Where
It's in the,
One of the admitted evidence.
did you identify?
Yeah.
this one?
Oh, sorry. FF. That was the emails. Correct. Right? Oh, yeah, yeah. If you go to pay in red 154 and it goes into 153.
But this document itself, all I see are here are a couple of emails and attachment link, but no actual documents. For commissions, we can't view that. Right? So I guess my question, were those accountings provided to the commission?
No, I'm sorry, I couldn't hear your answer.
no,
No, we're not provided.
You have an estimate for how much income you've taken, that has been earned from this property?
there was no earned income because at one point I had to redo the pool. The pool plaster. At one point, one of the tenants had destroyed the home, so I had to take all the furniture out. All the furniture was destroyed. I had to refurnish the property. I spent in exceed access of,
Excuse me, was that your question?
No, it isn't.
No, no, it's here.
sorry,
You're answering. Well, you didn't ask that.
I think you're conflating how much rent income did you earn compared to,
you're saying I
offsetting it
earned,
from
but there was no earn.
well,
Collected.
how much rental income have you collected?
I believe it's somewhere in the complaint that I answered Ms. Goddard. But I don't,
Okay, if you turn to NRED 311, read the green binder.
The green binder.
which one?
311. Bottom.
Oh, you're starting? Oh, got it.
Approximately 95,000.
But you paid all the bills associated with the home, including mortgage, utilities, et cetera.
Correct.
And now here today, you also represent that you've made large capital expenditures to repair the full mortgage.
Correct.
But again, no documents that are in support of that have been provided to commission, just your representation here.
That is correct.
Did you ever make an accounting of your rental income to your father? Or-
Yes, that was in the email that I sent to him. And then I sent it to I attached statements to that email in FF is him sending me his accountant's information, and then I would forward it to his accountant.
Okay, so it is in this email as an attachment, but unfortunately, you didn't provide the actual account.
That is correct.
Do you ever remember making any disturbances of the incoming rental income to your father while he was alive?
There was no disbursements. He never made any money from the rental.
I understand that there were payments that you made to maintain or upgrade the house.
We always took a loss every year so that we didn't have there was no disbursement.
And again, just to confirm your testimony, you said that he had a key to the property and you never changed locks to it.
That is
So if he wanted to, he could have moved in. That's your representation.
absolutely.
Let's turn then to the district court proceeding. Real estate professional for 14 years.
Yes.
You didn't find it somewhat odd that you didn't need to appear for a trial on a case where your ownership of stake in the house might have been at stake?
No, I had never been sued before. I was very naive. I listened to my attorney. My attorney gave me the advice not to show up.
Right. I looked up the district court proceedings. Weren't you involved in a separate maintenance complaint with Charles Jett back in 2007?
No, that's my husband.
Yeah, I understand that, but I do have a court case that I pulled up from the district court website indicating that you were involved in a case in district court. This is.
Check, this is
2007,
well beyond.
I don't even know it.
I am testing her on her statement that she had never been party in.
Can I finish the objection or just gonna?
Go ahead.
this is well beyond the scope of the examination. And it assumes facts not in evidence. Don't see.
Volume. They can't hear you at all. Sorry. They can't hear you.
I'm sorry.
They're all pointing.
Apologize. It's beyond the scope of the examination. Never mentioned this at all. Didn't go back there. Here's that somebody can retry the prior case and some of us can't, and that's why I'm saying this is well beyond the scope.
I object to that as an inaccurate statement, but that being said, I will voluntarily withdraw.
It's abstaining. You don't have to.
Thank you very much. Okay, I think with that, I'm done with my questions first. Thank you.
It is.
Yeah. If you
Correct.
redirect, yes. And for the record, Josh Bloth, behalf of Karina Jet. Okay, so if you could go to Exhibit R.
Is there a number?
Bait stamp, 111.
Yeah, you could tell us those. because
Oh,
we don't
yeah,
know.
it's probably easier to, it's easier to just, search that up. Okay.
And is it NRED?
KJN Red. This is in defendant's exhibits. Yeah,
Okay.
respondent, sorry.
I can help you. He helped me.
Hey, I appreciate it. I would like you to look at where it says, please indicate which privileges you wish to grant to the third party named above. Can you read what the third, I guess, option is?
Update existing tax information.
And is that checked off?
Yes.
Okay, now if you could go to Exhibit W. And do you know what this utility was for, or if it was a utility or it was something?
I believe it was the Clark County taxes, but I'm not 100% sure.
So in regards to the authorization that we previously looked at as Exhibit R, did this give you authorization to, I guess, inquire about property tax information?
Yes.
And then could you please turn to, this is going to be in red 311.
Thank you.
Yeah.
I see that.
Okay. And you previously were questioned, and it was regarding the amount of money that you received from the renting of the Luster View.
Yes.
Do you know what the net number would be in terms of after bills associated with the house were applied?
We were at a loss. I don't know though. I don't know. I don't have exact accounting.
And that's it. That's all I have.
Commissioners.
No questions from me?
I got a couple of questions for you. If you warned your father multiple times in your testimony that there was mortgage fraud, why would you turn around and attach your license to it by going on as ownership? And if so, and you had ownership in the property, why would you stop making payments upon his death?
Okay, so that was like two questions,
Mhm.
right? So the first question is, I did not know at the time that my father was going to change his mind. Added me to the property initially from the beginning of the purchase. So I did not know at the time that my father was going to change his mind. And I stopped paying on the property at that point because I was being sued by him. So I wanted it to, I didn't want it to be spending any more money because I had to spend money to represent myself and, you know, I ran out of money.
Well, this closed in April. And he made his first mortgage payment in June. And you said right after that, he said he's never moving into it. Why
Correct.
wouldn't you remove yourself from the property at that time?
Like, take myself off the deed?
Yes.
I don't understand.
If it's attached to mortgage fraud, which is what that would be, because you warned him multiple times that there was fraud involved. If he didn't move in, then why wouldn't you remove yourself from the ownership of that property?
Maybe I was hoping that he would move back in. Maybe I was hoping that he would change his mind and come back. I mean, I begged him to come back multiple times. I mean, he had a very tumultuous relationship with her. There was a opportunity for him to move back into the house. And was hoping that he would move back.
Any more questions?
Oh, yes. Yeah, Commissioner Barbie, I've got a few. Precisely when was that decision or the discussion of you becoming a joint tenant? When was that really determined? During middle, whatever part of the transaction?
I believe that it was, you mean like from the beginning, like when my.
Is this something you discussed even during the transaction, before the transaction? When was this a thing?
I think my father's intention the whole time was to add into the.
Okay. Given that answers that question. Given that, and considering his age, and considering there were 4 wives and kids and half kids, right? Did you reach out to like a real estate attorney or a trust attorney to assist with even determining if this was the right direction to go, or to find out if maybe deed upon death were a better route, or an actual revocable or irrevocable trust was a better route? Was some other professional brought in to help in that decision making?
No, my father was very secretive about his will. I did not know the contents of his will. He was very secretive about it, so I did not know what was in it. So I didn't. And this was, he knew that this was the best path for me to receive the home, because.
How would he know if a real professional with that expertise was not brought in to validate or verify that?
How would he know?
That this was the best route to take?
I believe he was advised by the escrow company.
They're not trust attorneys. Okay, but fair enough. That's fine. I mean, me personally, I'm gonna get an elder law attorney. They know things that other people just don't know, but that's neither here nor there. So let's switch gears now. Let's talk about the rental, because this is in, not in the city of Las Vegas. The property is in the unincorporated Clark County, Colorado Ranch, right? And so they have some very specific ordinances and rules regarding short-term rentals. Beginning with, so did you have an actual business license for short-term rentals from Clark County?
It was, even though it was rented on Airbnb, it was not rented as a short-term rental. It was rented over 31 days.
Every time over 31 days?
That is correct.
Did the HOA permit that?
Yes.
Okay. So there was no business license in Clark County. So you
I
didn't,
believe at the time, I did over 31 days, so there's no business license. And then I was it was brought to my attention at one point with Airbnb that I was no longer allowed, or with the HOA that I was not allowed to do, and I stopped at that point.
Okay, so
Then I changed it to MLS.
and then you did what, minimum 6 month to 1 year type
Correct.
rentals?
Yes.
Okay. Did you or your father or the two of you together set up a business entity for this separate business enterprise, either as a sole proprietorship, LLC, corporation?
No, we didn't.
And so then there was, I'm assuming then there was no Schedule C filed on the income and the expenses associated with the rental business?
So how my father and I decided to do the taxes is we took half, like I scheduled half. I took half of the responsibility of the house and he took the other half. So when I sent him, we split the responsibility down the middle. So when I would send his, the statements to Brian, his accountant, then he knew to split, like I would take a responsibility for half of the house and he would take.
Okay, and that was a contractually agreed upon in writing?
Was not agreed upon in writing. It's an agreement between me and my father, but it reflects on his tax statements and mine also.
Okay, because his treatment of tax and yours would be vastly different based upon the same income and expenses because you're a full-time realtor.
Correct.
Okay, just want to get that clear. And then really the last thing is just kind of a minor thing, but with the bills, why wasn't there a simplified way to get bills early on, like a PO box or through email so that you don't miss these things? Because, you know, some of these people, but not only HOAs, but if they're SIDS and LIDs, I mean, they go crazy and foreclose on you immediately. So, I mean, I would think putting some priority to making sure you were going to get the bills so you could handle them would have been very important.
I mean, I did not have a lot of experience at the time regarding rental. So I'm not a property manager. I was just managing the property myself. So as an owner, so I was just learning as I was going, and I was kind of thrown into this because my father decided to rent the house and leave. So it was all like I was learning as I was going.
Thank you very much.
Any questions? I just have one for you. So you had a VA loan on there. You were very much aware of it.
Yes.
When did you first rent the house? First tenant, when did they move in? I know you said it somewhere. I have notes.
I believe July of 2016.
2016. So you had a VA loan that you were aware of and you were renting it out and you said your father wasn't there, correct?
Correct.
You do agree that's fraud?
Yeah, I do agree with that. And I told my father that, but
I'm not worried about what you tell your father. I'm worried about your obligation. As part owner and a licensee, he's not here to defend himself on any of these accusations.
I understand.
Nothing. So I'm asking you. So it is fraud. Committed fraud. You would agree?
Object.
I don't agree because
I didn't hear it.
So should I answer the question or not answer?
You could just repeat her answer. She said she answered. You're
You can finish answering.
I mean, I didn't feel like I was doing mortgage fraud because I was not on the mortgage.
You have a real estate license, right?
I understand.
Okay, thank you. Any further questions, anybody, just in case? No? All right, you're excused. Thank you.
Okay. You want to go to this one? Okay.
I'll take a break.
5 minutes.
I live that life.
Thank you.
Karina.
Maria, are you and the virtual attendees ready?
Yep, I'm ready to go.
Okay, thank
Ready?
you.
Thank you. Okay, I think we left off, you have one more person,
Yes.
one more
I'd like to
witness.
call Joseph Scott.
Joseph Scott. Hey, you going to? Let me swear you. You see, you didn't even know. Okay. Bear with me so I don't.
Oh, sorry, I didn't mean to rush you.
No, I was talking to him. Surprising. All right, raise your hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth, nothing but the truth?
I do.
Thank you, sir.
Mr. Scott, will you state your name and spell your last name for the record, please?
Joseph Scott, SCOTT,
Mr. Scott, how are you currently employed?
with Keller Williams VIP. I'm the managing broker.
And is Miss Jet, how do you know Miss Jet?
She's one of my agents,
Okay, and how long has she been one of your agents?
for over a year now, I think about 16 months.
Okay, and when she first came and talked to you about moving her license to your agency, did you have dialogue about this case?
Yes, actually, and I really appreciated it at the time because a lot of agents, if they join your office and they have a pending complaint, you might not find out about it for 3 or 4 months later. And Karina was very forthright and came to me first thing, and we spent several days talking about this, and she was asking me about it because, I do have the discretion to not allow an agent to join the office. And for instance, last year, I got rid of 3 agents that I felt had ethical and behavior concerns, and they were good producers. But we got rid of them because we didn't want our office to be at jeopardy. And so after reviewing this case with Karina, I felt like she had a horrible attorney and a case.
Not me.
You weren't in the picture yet.
Okay, let's check. I just wanted Miss Ruth to know that.
And the jury's still out on you, by the way. But I feel like she had a horrible attorney and a vindictive family. And I thought she had a good heart, and I welcomed her into the office. And since then, I've not had a single complaint. No, as brokers, you guys are all brokers and ladies, you get complaints sometimes on agents. Someone gets upset and they call up and, sometimes it's something and sometimes it's not. I've not had a single client call in and complain about her. I've not had any issues. And like Jeff Moore said earlier, she can be a little bit of a pain in the butt. She's a great person.
When you said pain in the, then you said but, were you with 1 T or 2 T's?
2 T's in her case. But I mean, I don't know. I feel like she's been a good person and a good agent in our office, and we're happy to have her there. And I know some of these things don't look good sometimes, but I've had some bizarre complaints about agents. People call up and, after you take time to review the cases and go through the same way the real estate division would, you find out that maybe that, there's not always a legitimate complaint, that someone's upset and they're being vindictive.
How many transactions has she done while she's been at your agency?
I could not tell you that off the top of my head. If you give me a minute to text our.
No, that's fair.
MCA, I could find out.
She has done some, correct?
She has. In fact, she just recently closed a couple of deals over $2 million.
Okay.
Each.
And you've reviewed those deals?
Right. They go through compliance. Everything goes through compliance.
And do you have any questions or concerns about her ethics or her business practices or anything associated with any of the transactions that she's had while she's been at your?
Nothing I've seen. And in fact, her transaction coordinator is a former attorney, and she's very precise with things, and I think they do a great job.
You reviewed the case, some of the elements of this case, correct?
I did, and it's been quite some time since I did that.
Okay. And yet you were prepared and willing to hire her despite the allegations in the case.
Yes, because I felt like after I was presented with the facts that, like I said earlier, she had a bad attorney. I mean, I've never heard of an attorney not presenting evidence and telling the client not to show up to court or in court. That was, and I feel like she was probably a little naive because there's no way an attorney could have talked me into not showing up in court for my case like that.
Okay. Given everything you know today, would you continue to hire her?
Yes,
I have
I
nothing.
think so.
I have nothing further.
No questions. Thank you very much for your.
Okay.
Well, any
done?
questions here?
No.
No, you're excused. Thank you. Okay, Vision Council closing statement.
All right, very good. Thank you very much, commissioners, for paying attention to all the details in this case. It is the division's position that we have proven violations, all four of them, beyond preponderance of the evidence. I understand that there, respondent has to make the arguments that she can based on the circumstances. They're unfortunate, and yet we do have not only the district court's determination that went through all the cases. We're talking about appeal, through appeal, span of 4 years. So there's that. Separate piece. The division had their own investigation, corroborating those details. I understand that Ms. Jett believes that she didn't get, she was short shrifted and didn't get to communicate with the investigator as much as she would have liked to. Nothing is stopping her from reaching out. I think I established on a counter on my cross-examination that investigator Goddard reached out to her multiple times, not just the once, and asked her follow-up questions. And I think the totality of the evidence, when you look at what passes its sniff, what makes the most sense, is the case that we present, not the one where you kind of have to suspend reality in order to reach some of these conclusions. I believe that my cross-examination of the respondent kind of highlighted that there are certain inconsistencies regarding, well, here I am paying all these utility bills, paying all this except the mortgage. I mean, we understand why, because it was based on fraud. There are ways that she could have made her way out of. Commissioner Marina had a very good question about why she didn't remove herself from the fraudulent situation. Why indeed? A real estate professional, 14 years. She testified she knew that was fraudulent, that it was a crime, but she was hoping beyond hope that her father would see the light. I mean, her testimony to be believed. He moved in with this other lady, this home that was far away from hers, and I don't know. It requires a bit more suspension of reality than what the division's argument is. That the evidence that we determined in our investigation to be truthful, the more likely case is what happened. There's an additional question from Commissioner Barber. Why was someone else not brought in to consult on this? Why indeed? 14 years of experience in real estate, and you're talking about a situation that's a bit prickly, that you're gonna have commingled funds, rental funds, expenses. You're not gonna try to create some kind of alternate arrangement. Instead, just let things go however they're gonna go, have delinquent liens, no auto pay. These are things that just don't pass the sniff tests. Really think about it. And so that's what brings me to a couple other final points. I do want sale clause. This respondent Jett knew or should have known that by getting a deed from Peter Senior for that half interest, he may have violated the due on sale clause of his own lease. That would have triggered a foreclosure in and of itself. These are things that I don't know that a layperson would know, but I think a real estate professional would be held to a higher standard. I think that's the overarching theme. A real estate professional, especially in this day and age where mortgage, lots of concerns regarding like integrity and profession. And I think it's true of many professions, but especially this. You have somebody who is found by a district court to have engaged in fraud and inducement, misrepresentation, and here we are supposed to first slap on the wrist. What message does that send to the public? What message does that send to our industry? I think it's a disservice. And so on that basis, first of all, I believe that the division has proven its case as far as the violations, as far as the facts. And I will defer to my counterpart with the division chief as far as disciplinary conditions thereafter. But on that basis, I urge you to find the violations. Thank you.
Thank you. Is the respondent's time or counsel for a closing statement?
Thank you. This is a difficult case for a lot of reasons. One of which highlights something that Mr. Suja has said 5 times just now. Someone with 14 years of experience. That's not what happened. Sorry. She had 2.5 years of experience when the transaction occurred. It's been 14 years since it occurred, yes. But what she knew, what she knows today, she would absolutely do differently than she did 14 years ago. But she was licensed in 2012, 2013, and this transaction occurred in 2015. And it's with her father. And her father that she was trying to help out. She was trying to do something. We keep talking about the other case, but if you remember about Miss Goddard, she relied heavily upon that other case, and she relied upon the findings of that case. But the claimant in this case didn't even testify in that case. The claimant in this case is the granddaughter, and they all think that she was taken advantage of. I get it. Candidly, this case should be dealt with more with Dr. Phil than with this court, because it's an emotional issue. It's a family issue. If you remember what they were talking about, 20 houses. She went and showed him 20 houses. And she was trying to figure out what to do. I asked Miss Goddard, I said, okay, but isn't putting your daughter on the deed as a joint tenant, that's a great way to avoid probate. In fact, candidly, if that's fraudulent, I've committed it 100 times. Because I tell everybody, if you've got a child and you want to pass your house without to avoid probate, which is a miserable experience, put them on deed on joint tenants. Agreed. Now there's an interesting issue about fraud in the VA that everybody asked about. At the time of the transaction, my client believed that her father was going to be in the home. And she testified to that. And he was going to, and guess what? He changed his mind. That doesn't constitute fraud. That constitutes somebody changing their mind. Fraud would have been, hey, Dad, by the way, instead of saying that you make $100,000 a year, say that you make $200,000 a year. That's different. There is no fraud to have. The idea of the transaction was he would buy the house, he would hold the mortgage. You can rent out rooms in a VA loan, provided it's your primary residence. Okay, and she testified. I told him he needed to do that. Then you asked the question, Ms. Ruthie, when did you lease it out? Okay, transaction closes in 2015. The first rental was July 2016. Went a whole year. So it's not like, okay, let's hurry up and get everybody in there. No, we were trying to get everything. She was trying to see what, let things play out. And again, she had only been a real estate agent for a couple of years. And then she came back and this occurred. And now we're 14 years later. I find it curious that if this is such a fraudulent transaction in 2015, why'd they wait till 2023 to file the claim? Why did they wait until everything else figured out? They didn't have to wait. There's nothing anywhere that says you have to wait for the civil court to finish before you file your complaint here. It's vindictive. They thought, you know what? Hey, we won here. Let's take another shot. We got it the first time. Let's go get her again. So let's go take away her entire livelihood. It's vindictive. It's a vindictive nature. It's a vindictive act. Because the way I know that is you just heard her broker said, you know what? I'd hire her again. You heard her prior broker say she's a pain in the butt, but I don't remember anything else out there other than she's difficult to deal with. Well, candidly, you all know I'm difficult to deal with. Okay, but that doesn't mean that I don't do my job well. And she tried very hard to do everything right, and she's in this horrible. I'll apologize to you all for this. I'm a poor dumb farm boy from northern Utah. And I was in the middle of a federal case one time, the most preeminent federal judge out here that you don't want to upset. And I said something then that I regret because every attorney behind me just inhaled horribly. And I said, Your Honor, the problem is my client found himself literally between a dog and a fire hydrant. She was in a rough spot because her dad was wanting this and she was wanting to help her dad. And then he changed his mind and she didn't want him to go live with the girlfriend that was the mother's ex best friend. And yeah, she's in a bad spot. Does that warrant taking away her license for the rest of her life so she can't work? And then what happens is you start to look at the information that wasn't presented that should have been. I am appalled at what happened at the civil court, at the state court level. Appalled. I can't even imagine. Yes, she should have been there. Yes, she was naive. I can't imagine any attorney saying, yeah, don't worry, don't show up. And then presenting one document, which was the deed that put her on. And I apologize because I did say there was no evidence, but there was one document presented, which was the deed that transferred it from his individual sole proprietor or sole ownership to them as joint tenants. And let me correct counsel. She didn't own 50% of the property. They're joint tenants. She owned 100% of the property and they both did. And so she put herself, and even if she would have wanted to sell it, she'd have to get him to do it. And he may or may not have agreed. So there's all kinds of complications with this. But remember, now we've got this, according to the complaint, oh, she's out there trying to take advantage of him and everything. Okay, then what does he do? In 2016, 2017, he goes to the Department of Veterans Affairs and says, I want my daughter to be my power of attorney if anything happens to me. The very person that they are alleging was taking advantage of him, he came back and said, I want her to make every life-ending life healthcare decision there is for me. And candidly, I don't see anything that rescinded that power of attorney. So she could have done anything she wanted because she had the power of attorney from him, from the Veterans Affairs Department. And it showed that second daughter was Michelle Carpenter behind the most trusted daughter, which was Karina. And then we had the whole issue of where the bills were going. And yeah, that's confusing. You're probably right. She probably should have gone down. There's a lot of things that, Monday morning quarterbacking, looking in the rear view mirror, she probably should have had a separate account. She should have put all the money in that. It was her dad. They were two people that trusted each other. And some of the bills would go here and some of the bills would go there. And when she finally got them all straightened out, they all started going to the same place. They all started getting paid on time. And then the question was asked, well, how much money what was the total amount of revenue you received? And it's interesting because in that exhibit, she writes back and she says $95,000. Then they stop the rest of it. It says, however, I paid all of the bills associated with the home, including the mortgage, utilities, etc. And then she testified, we never got to the right side of red. We were never profitable. Question was asked, then why'd you stop paying the mortgage? Because I was being sued and they were trying to take the house away from me and I was running out of money. She were paying attorneys that didn't want her to show up in court. And now she's in a horrible spot. There was an email that shows, look, here's the income statement that she sent to her father. Unfortunately, the document wasn't attached to it, but at least there was an email showing that she was trying to keep him advised. Then there was the insurance that went to Peter at the Clear Blue address, but then the renter's insurance went to my client at her house. So it's all over the place, obviously. But it gets to the point that what happens is they decide that they want to make sure that everything is done. So what does Peter Sr. do? He goes to the bank and says, I want to put you on all my accounts so you can address this. So he puts the power of attorney, puts her on all the bank accounts. This isn't somebody that's trying to take advantage of them. It's somebody that he trusted. Now, again, I struggle with the fact that if this was such an issue in 2015, why did we wait till 2023 to file anything? Why did we wait until after the civil court? Why didn't we wait till after the appeal? There's nothing that would have stopped them from filing in 2017 when they found out about it. But instead, they wanted to go extract a pound of flesh, and they got that. And they're going, hey, you know what? Sharks in the water. Let's go back and get another pound of flesh. She did not, she admitted she did not have experience as a property manager. She was learning how to do that. But again, we're talking about 2015 or 2017. We're not talking about 2026. The loan closed in April of 2015. Questions were asked, well, then why did you take your name off the title? Well, at that point in time, there was no fraud. Her belief was that he was going to own the property and move into it. When he didn't, the question becomes, why is it fraud after the fact? That's a question. That's a difficult question to answer. And her response is, you know what? I'm trying to help my dad out. And he had promised her that he was going to do this. This was all of her inheritance. But the other issue is, even if she would have said, Dad, you know what? I want to sell the house. He would have had to sign off on it. We're not certain, given what we know about him, that he would have done that. We would have just been in another lawsuit. Ms. Goddard, and I appreciate everything that she said, and it's difficult, but I asked the question, you reached out to everybody else, you were interviewing everybody else. Why didn't you just reach out to her? I don't know that I've ever heard of an NRED investigation where you don't reach out to the person charged. And one of the struggles in this case that's really difficult is we've got all of these allegations from Yvette, who didn't show up at the trial and didn't testify. And my client was told not to show up. Yvette's not here today to testify. My client has never had that constitutional right to confront her accuser. Not that you have to do it in this setting, I agree. She's never had the right to go sit down and say, wait a minute, call it BS on that. And here's why. They were taking this, they wanted the district court, you know, it's one of those things where I remember one time going to court and I walked back in and my partner said, how'd you do? I said, I won a motion for summary judgment. He says, hey, congratulations. I said, well, let me tell you the other part. Nobody else showed up. Pretty easy to win those. A lot tougher to win the ones where somebody shows up and actually presents defenses. You have seen the defenses. You have seen the emails, or the text. You have seen the fact that there were bills sent back and forth. I guarantee you that the outcome of that civil case in district court would have been very different had there been a defense presented, had some of the documents. It wouldn't have been a half an afternoon case. It would have been a much longer, it would have taken a couple of days. And if you look at even the Supreme Court rendering, the Supreme Court was basically saying, look, based upon the record, and I don't know how much you all know about that process, you take the record, you take the transcripts, you move that up to the Supreme Court, and that's all they get to look at. What did they don't get to start all over again. And so they have to just say, she didn't show up. I don't have any defense. What's really important in this case is this. You get to do a de novo review. You get to go back and say, I don't have to pay attention to that state court proceeding. I don't have to look at the Supreme Court issues. I get to look at Karina Jett right there and say, okay, do I believe you? Do I believe that what your intentions? How do I feel about you? And based upon your actions, do I feel strongly enough that I'm going to take away your meal ticket, your ability to work as a realtor? And that's what we're asking you today is that you don't do that. Give her the chance to go back and continue to be a realtor, because we have one instance that is really ugly all the way up till today, and say, hey, you know what? We're going to give you a do-over. I don't know if any of you golf, but this is a mulligan. We're going to give you a do-over. I disagree about the allegations about whether they prove their case, because when they say that she committed deceitful, fraudulent, dishonest acts in the real estate transaction, she testified, no, I believe my dad. I believe, and I told him not that if he was going to do this, I told him after the fact, if you're going to do this, this is a problem. That's not deceitful. That's him making bad decisions, not her. And with regard to violating the other claims, failing to possess the qualifications of honesty, trustworthiness, or integrity required of all licensees when it was uncontroverted that she committed fraud in the inducement. What fraud in the inducement? He was the one that said, I want you to find me a house. He enlisted her to go find a house. He signed all the documents. He transferred it from himself, and it's his signature, transferred it to her in joint tenancy. That's not fraud. That's him. And it was notarized. He agreed to all of that. And then he changed his mind. That's not fraud on her part. That is his decision to make that. And he put her in a very awkward and bad position. Failing to exercise reasonable skill and care with respect to all parties in the real estate transaction. This is a tough one because she's trying to show respect to her father and trying to be above board. And you heard her testimony. She was never locked out, always had a key. Now, he may have lost the key. He may not have told anybody he had a key, but there's no evidence. One of the things that we asked her is, why'd you call the police to go in? If your name is on title, you can absolutely walk in there and get in that house. Anyone could have. Anyone could have done it. There's no evidence of that. There's no evidence other than, well, she locked him out. And her testimony is, I didn't. He had the key. Well, unfortunately, he's not here to say that he was locked out, but there's no police record, and they do them civil standbys all day long. Call up the police department. They show up with civil standby order, and you got the locksmith there, and they change the lock right there, and they hand the owner a key, and it's that owner's responsibility to give it to the other owner if they want to. So there's no evidence that that even actually occurred. Committing grossly negligent or incompetent acts when she breached her obligation of absolute fidelity to her principal father's interest, her obligation to deal fairly, and instead advance the owner's interest of herself. She didn't make any money on this deal. Her dad said, look, I saw some eyes rolling when it was, yes, I'm the daughter of the fourth wife. Okay. Now you got fourth wife, one daughter, prior wife, several kids. Kind of hard to have a Thanksgiving dinner that's not going to be awkward. And so he wants to go back and say, you know what? I'm going to take care of you. I kind of don't want them to know about it because I don't want to deal with it. And then when they all find out about it, they deal with it and put her in a bad position. But nobody was there. And even Miss Goddard didn't sit down and talk to her and say, what were your conversations between you and your dad? So this has been, and I appreciate your time, and I apologize. I told Commissioner Ruthie that I apologize. I haven't done a lot of these, but every administrative hearing I've ever been to, not here, meaning I've gone to about 6 or 7 different administrative hearing organizations. The rules are always different because you all have the discretion to apply the rules as you want. I apologize for that. I certainly, when I was rolling my eyes, was not intentional. It's something my wife accuses me of all the time. But the issue is, let's look at what really happened here and what the outcome is. Does what happened warrant her losing her ability to act as a realtor when her broker says, no, she's really good at what she does? And this is the only blemish on her record of 14 years. And all of this happened when she had been out for 2 years. Not today. It's not like it happened yesterday. All of this occurred in 2015-16 timeframe. We're 10 years beyond that. And I would hope that what you would do is consider all of the facts and consider the fact that she really kind of got hosed by her attorney at the civil court. And there was great, and you should be able to rely on the civil court proceedings. If that proceeding is a fair proceeding, this one was not. And with that, I hope that the commission will grant her the ability to retain her license and continue.
Thank you. Okay, at this point, the hearing is now closed and the commission to deliberate. During this time, neither party can offer additional information while the commission is deliberating. Anybody would like to start?
I would like to do, if no one wants to discuss, I'd like to do the first motion of factual allegations.
You're talking extremely low, Ms. Commissioner.
Everyone is today. I said if no one has anything to say, I would like to do the first motion of factual allegations.
Okay, just let me check 1 minute. Anybody wants to speak about anything before Commissioner Tina starts? No? Okay. So are you take them one at a time or in a group?
I take them in a group.
Okay, great.
I move that the commission pursuant to 645-860, find the state has proven that the factual allegations 1 to 11 -5 are true and proven by the statute and custom.
I'll second.
We have a first, we have a second. Do we have any discussion?
If no one knows what 5 is, that's the one where they're saying that, she locked them out of the house and said, it's my house and I won't live with an old man. I didn't see any proof of that in anything we saw.
So we have a motion of 1 through 11 -5. We have no further discussion. All those in favor say aye.
Aye.
Opposed? Chair votes aye. Motion passes. Okay. Now we are going to discuss, if there's any further discussion, we'll go on with the violations. Is there a motion?
Like 5, got a vote 5.
You have 5?
Motion on, I think that was not in that routine. That was.
Oh, thank you. Okay. So do we need another motion for it? So would you pass?
Certainly, I move that, that allegation 5 out of 11 was not met by the state.
Second.
We have a first, a second. Any further discussion? Hearing none. All those in favor?
Aye.
Opposed? Chair votes aye. Thank you. Okay, now we will go on with the violations. We have 4 violations. Take them all at once or separately. Any discussion on it? Okay, hearing none, is there a motion?
Okay, Commissioner Barbie, I will make a motion that violations of law can be, oh, wait a minute, is that the motion?
Any violations?
Yeah, violations of law can be taken as a whole or individually as approved. I moved in this case of NRED versus Karina Jett, case number 2024-680, that all violations 1 through 4 have been approved.
Second.
Okay, we have a first, a second. Any further discussion? Hearing none. All those in favor?
Aye.
Opposed? Chair votes aye. Motion passes. Okay. At this time, we will ask the recommendation for discipline. Our chief compliance officer.
Rebecca Bruce, chief for the division. In this case, the division is recommending a fine of $40,000, which consists of $10,000 per violation found, plus the costs and fees of the investigation to be payable within 90 days from the execution of the order. The division is also recommending continuing education in the amount of 18 hours, 3 hours each in ethics, agency, law and legislation and risk management, and 6 hours in contracts, not to be applied towards the renewal requirements for continuing education.
May I ask you to repeat the education portion for me?
Yes, 3 hours in ethics, 3 hours in agency, 3 hours in law and legislation, 3 hours in risk management, and 6 hours in contracts.
Thank you.
And that is to be completed within 6 months of the order, the execution of the order.
Thank you. Commission coordinator, I did not swear you in yet, no, so I'm going to need to do that. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth? I do. Thank you.
Amy Reverend, for the record, Commission Coordinator. Um,
Wow.
wow, I appreciate that.
Theme of the day.
And, one moment. Back. She's back.
I'm back. All right. So the total cost of the hearing is $15,676.64. And those fees are actual, reasonable, and necessary.
So we have the fine, 40,000, cost and fees, 15,676.64. And we have the CE credits of 18 hours, all due in 6 months of order. So at
6
this,
months or 90, was it 6 months?
she said 6 months. It was 6 months, correct?
With 90 days for the fines and 6 months for the education.
The education, yeah.
I'm gonna ask if there's any way we can get more time on the fine, because that's a hefty number.
Right now, we
Sorry,
we're deliberating.
sorry.
Commissioner, I'd like to make a motion.
Can I check if anybody wants to? say
Yes,
anything
I'm sorry.
Before you run into your motion.
Yes, me.
Anybody have any comments they want to say?
Oh,
Okay. Yes, you
Commissioner,
do.
only one thing. I appreciate the fact that, that we are not looking at either revoking or suspending the license. I appreciate that.
I'd like to, and tell me if this is okay. Lots of attorneys in this room.
Not
May-
okay.
May I allow? I wasn't including those. I can't. Yeah, I just learned something. Okay. Go ahead, Mr. Commissioner Tina.
You ready?
I'm ready.
I move in the case of number of 2024-688, NRED
No, 680.
680, I'm sorry, I dyslexed it. NRED versus Karina Jet, that the commission finds the allegations in violation of proven, and the respondent shall be fined 40,000 plus the costs of 15,676.74, all to be paid within 90 days to the date of the order with the standard collection language. CEs must be completed, 18 CEs within 6 months. These CEs will not count towards the C requirements of all license renewal and must be live classes.
Do we have a second?
Second.
We have a first, we have a motion, we have. Did you say about the 90 days payment?
Thought I did, yeah, 90 days.
Thank
Can
you.
you specify the courses again?
Oh, you want me to read the courses? Wow.
Just to be sure it's in the order, sir.
At 3 hours ethics, 3 hours agency, 3 hours law, 3 hours risk management, 6 hours contract. To make 18. Thank you.
Thank you.
Can I ask a clarifying question?
No, not at this time.
It has to do with what they just, it said they all have to be live. What if they're not all offering live?
They are.
Okay.
Okay, so we are ready to vote. All those in favor?
Aye.
Opposed? Chair votes aye. Motion passes. Okay, hearing is concluded. Thank you.
Thank you.
Council.
Yeah.
So, you know. Just put it into there. We break them.
The meeting is not over. Oh, your hearing is concluded. You could leave and if I want to leave, yes, yes.
Council, I get to see all the time if I stay.
Try for
I
that.
get to see how if I stay long.
You get jail time.
Trying for that CE.
You're gonna get jail time.
Appreciate it.
You know, time to meet, I get time to sleep.
That's it.
I mean. Oh,
Thank you.
Commissioner Rutten, that the instructors are saying they have to be dismissed for this. This, you have. Oh, okay.
Yes.
It's only that piece just included, but not close the meeting for the day yet. So we'll give everybody a minute to settle. If you are leaving, feel free. That's your choice. But at this time, the meeting itself is not. She is, but she's not gonna, yes. It's like, I wanna go. So this is gonna be fun.
Have the option.
Okay, so I'm gonna do the, excuse me. Don't want to know this. Hit me. Okay, I'm going to, we're not done with the,
Excuse me, those of us that are here for CE, can we leave?
can you,
Those of us that are here for the CE?
almost done. We're almost done.
All right, thank you. Hi, Dave.
Members of the public are encouraged to address the commission regarding any matter. However, no action may be taken on a matter. No comments may be made regarding a matter that is or may be the subject of a formal complaint before the commission. Comment may be limited based on viewpoint. Individuals who desire to submit written testimony should submit to the commission coordinator. Anyone that would like to make a public comment should press *5 on your phone to raise your hand, and the hosting staff will recognize you. Or if you would like to give public comment, you could also press 6 to unmute yourself and state your name. If you're attending by video, click on the raise hand emoji to indicate that you would like to give public comment, and the hosting staff will recognize you. Or just unmute yourself and state your name. So, anybody here, public comment? Okay, anyone in Carson City? Maria, anyone
No
online?
public comment from Carson City.
Thank you.
Anybody virtually wishing to give public comment, please use the raise hand emoji, or you can unmute yourself and state your name. I am not recognizing anybody who would like to give public comments.
Okay. Meeting is adjourned. Credits and waiting. Thank you.
It's recessed.
Recess.
Recess. We're not adjourned. We're done. We're recessed.
Until next, until tomorrow. Okay, we are recessed till tomorrow morning at 9 o'clock.